Welcome, everyone. This is my second to last session of the year with a student. I have one more session tonight, and then tomorrow, the student and I are meeting again for the MBE. But I wanted to do something special at the end of the session, which was a premiere reading of my complete Florida Bar essay guidebook. And I think it's comprehensive, and yeah, she's excited. I'm excited, and I think hearing it right before the test will jog your memory and equip you with the tools necessary to write outstanding essays on the exam tomorrow. So just as a little preface, my graphic designer is working on the logo, the cover, let's call it the cover right now, but it's going to be some interpolation of this picture right here, me and my grandpa playing whatever. We're not going to use this one, but this is us, smiling. And then, of course, the letters that you'll see that this whole thing is kind of based upon. It's pretty cool. And you can see 1997 was written by my grandfather, a whole slew of letters. So I've kept these on the back. Even there's Stick Boy himself, right? So that will hopefully you'll see that in the cover and you think that's pretty cool. But I understand how everyone's feeling. The test is tomorrow and it's nerve-wracking, but at the same time, it's just a test. Just go out there and do your best. As long as you've been working hard, or as long as you put your best foot forward, and ideally the combination of those two things will result in a successful experience tomorrow. So I'm going to go ahead and start sharing my screen and get right to it. And take notes. If you have any questions, just leave them for me. We'll talk about them, my student and I, and then anyone else can leave them in the chat. I've included a link to this guidebook so you can read it on your own, and that's for a limited time. I'm going to edit this some more before July and take care of all the details so I can package it as a sellable product. But for the next 12 hours, it's available for anyone to enjoy. So good luck, everyone. Let's strap in and read about Stick Boy. So, The Legend of Stick Boy, a complete essay guide for the Florida Bar exam. Intro. Dear Grandpa Joe, how's the weather up there? I miss you and Grandma every day. I'm sure you both expected me to be practicing law and raising a family by now, but I'm still wandering down the road less traveled. Since we last saw each other, many things have changed, but somehow mostly everything has remained the same. Remember when I was 6 and I moved away from Miami to Philadelphia? I was so sad because I didn't want to leave my best friend behind. I've been feeling the same way lately. One day a few months ago, I opened a drawer in the desk that I still have from Uncle Steve's house and found some letters we wrote to each other almost 30 years ago. We used to write to each other almost every day, usually about our favorite imaginary character Stick Boy and his adventures. Reading those letters made me realize even more than ever how lucky I was to have been your youngest grandchild. I think about you daily and always carry your spirit with me. When I spoke at your funeral, I told the audience that rarely do people reach great heights and reach back for others, but you reach back for everyone. I often remind myself of what you told me, that as long as I'm committed to working hard, things will work out just fine. I know how much you valued education, how much you revered the law, and how much you lamented the fact that the cost of tuition had outpaced inflation astronomically over the course of your lifetime. I have a lot of ideas about how I can solve this dilemma and miles to go before I sleep. Right now, I'm leading a group of law school graduates in preparation for the Florida Bar exam. Over the holidays, I wanted to create something that would really help them, and I came up with the idea of writing a concise, comprehensive guide for approaching the different types of essays. I've chosen Stick Boy as a protagonist for the story, and my plan is to put my heart into this project and trust my intuition. I want my students to benefit from this guide by learning the finer points of the law in a digestible and hopefully entertaining manner. Above all else, I want to continue to fulfill my promise to always make you and Grandma proud. Love, Andrew. Chapter 2, Florida Contracts. Dear Andrew, my name is Stick Boy. The reason I'm writing this letter is because I'm taking the Florida Bar exam and I'm really struggling with essays. Can you help me, please? Sincerely, Stick Boy. Dear Stick Boy, I don't usually help students via letters, but since I've opened your letter on Christmas Eve, I will take this as a sign and do my best to help you pass the exam. Also, I must ask, is Stick Boy your real name? I have a long-lost friend named Stick Boy, although he'll be certainly much older than you now. Andrew, Dear Andrew, thank you so much. I'm excited to work with you. Yes, sir, Stick Boy is my name. Everyone in my family has a similar name. Stick Man, Stick Lady, Stick Girl, Stick Dog, and Stick Cat. We are the Sticks. I'm so thrilled that you can help me with my essays. I'm especially struggling with contracts. I just can't seem to figure out how to approach a Florida contracts essay. Thank you again, Stick Boy. Dear Stick Boy, you know how they say sticks and stones may break your bones, but words will never hurt? Well, that's how I want you to approach your essays. The more words you can fit in the allotted time frame, the better. Florida essays are graded on a rubric system, so you want to try and get as many points as possible. If you don't write enough words, then you will not give the reader enough opportunities to award you points. That's why I want you to aim for 2,000 words or 10,000 characters when you write each essay. As far as contracts essays are concerned, there's a mnemonic I want you to memorize that will help you frame your essay. The mnemonic is BFDBD, Buy Friends Drinks, Big Drinks. And if anyone sees me in Tampa tomorrow, I am your friend. This helps us remember the order of analyzing contracts essay. Probably Wednesday night after the MB. This helps us remember the order of analyzing a contracts essay. Body of law, formation, defenses, breach, and damages. So BFDBD. Body of law, formation, defenses, breach, and damages. If you can remember to structure your essay in this order, it will help. Also, before you even begin addressing the validity of the contract, you should answer a few key questions. Who are the parties? Are they merchants, for example? Is the contract bilateral or unilateral? Is the contract a special type of contract, such as options, requirements, output, or installment? You should structure the essay to directly answer the questions presented in the prompt, but fortunately, most contracts essays require the same format. Identify the specificities of the type of contract, determine if it's been properly formed and whether there are any valid defenses and counter defenses to formation and/or execution, argue that either or both parties have breached the contract, and provide accompanying counter arguments, and discuss damages. I think a really great way to write all Florida Bar essays is to utilize the IRAOC formula. Issue, rule, analysis, opposing arguments, conclusion. Please let me know what questions you have for me, Stick Boy. Andrew. Dear Andrew, awesome, definitely a lot to absorb. Thankfully, Buy Friends Drinks, Big Drinks is already a motto amongst the sticks. I'll try my best to write as many words as possible. I have a lot of questions. To start, could we go into more detail about those headings, BFD, BD? I just want to make sure I understand them completely. SB. Dear Stick Boy, as my grandfather always told me, taking care of the details is paramount. So sure, we can go through each heading individually. Body of law. Contracts are either governed by the UCC or by common law. Article 2 of the UCC applies to contracts for goods, which are all things movable. The common law applies to contracts for land or services. Examples of contracts that are governed by the common law are contracts to buy residential property, employment contracts, contracts concerning intellectual property, and contracts that call for performance. There are some contracts that include both goods and services. In this case, apply the predominant purpose test to determine whether the UCC or common law should apply. If the contract is mostly for goods but includes a small service such as delivery, for example, the UCC would likely apply as the contract is predominantly concerned with goods. It is important to note whether the parties are merchants because there are special rules that apply to merchants under the UCC, including the battle of the forms provision and the knockout rule, the confirmatory memo rule, the firm offer rule, the lack of need for consideration for modification, and the 30-day rule for responding to a request for further assurances. A merchant is a person who customarily deals with goods in the contract. Before addressing contract formation, it is wise to consider what type of contract we are dealing with. Here are some types of contracts to consider. Unilateral contracts can be accepted by performance. A classic example of a unilateral contract is a reward poster for finding Stick Dog. Once performance has begun, the offer is irrevocable, but the offer has not been accepted until performance has been completed. Bilateral contracts require contract formation, offer acceptance, and consideration. Installment contracts involve multiple performances or deliveries and can be perpetual. It is important to note that a minor breach of an installment contract is an exception to the perfect tender rule, as the breaching party will have an opportunity to cure the nonconformity in a subsequent installment. Requirements contracts obligate a party to purchase exclusively from another party all that is needed up to any amount required. Output contracts obligate a party to sell exclusively to another party all that is produced, regardless of the total output. Options contracts are contracts that are left open for the acceptor. At common law, consideration is required to create an options contract, but under the UCC between merchants, the firm offer rule states that no consideration is needed to form an options contract, and an offer can remain irrevocable for up to 90 days. Divisible contracts are contracts that can be split into separate contracts. Consider a contract to build 3 houses, likely a divisible contract in 3 parts, versus a contract to build a house including flooring, roofing, and electrical, likely a non-divisible construction contract. Divisible contracts can be segregated, which can limit total damages available. A divisible contract can also refer to applying both UCC and common law to the same contract, as opposed to the usual predominant purpose test. And this is only appropriate if the goods and services can be clearly distinguished by price. Quasi-contracts are fictitious contracts in the sense that they are not validly created contracts. Either they had a formation defect or they were created by the court in order to restore justice. Examples of quasi-contracts include contracts that have formation defects but are enforced under a theory of promissory estoppel, detrimental reliance, or contracts in restitution that are created to disgorge, my rapper name, ill-gotten gains. Quasi-contracts typically arise to prevent unjust enrichment of one party or to rectify unfair treatment of a wrong party. For instance, a quasi-contract could be created to pay back a tenant a deposit. Quasi-contracts are typically seen as a remedy. When you review model essays from the FBBE, you will notice that the body of law section is usually brief. You should inform the reader of the distinction between UCC and common law contracts. You should identify what type of contract we are dealing with, and you should take note of whether the parties are merchants or not, and if any special rules apply. No need to go crazy. Formation. Contract formation requires an offer, acceptance, and consideration. An offer is an outward manifestation of an intent to enter into a contract that gives rise to power of acceptance in an offeree. An acceptance is an indication to be bound by the contract. An offer and acceptance occurs when there's mutual assent and a meeting of the minds. There are some interesting concepts to understand about contract formation. The mirror image rule. At common law, the terms of the contract must match the terms of the offer exactly. If there's an additional term in the acceptance, this will constitute a counteroffer. The battle of the forms provision. Under the UCC between merchants, an acceptance with an additional term that does not materially alter the contract will constitute an acceptance, and the additional term will be included in the contract so long as the offeror does not explicitly reject within a reasonable time, typically 10 days. The knockout rule. Under the UCC, an acceptance with an additional term that materially alters the contract will constitute an acceptance, and the additional term will be knocked out of the contract, and the court will apply UCC gap fillers to complete the contract. UCC gap fillers consider the course of dealing as well as industry custom and trade and usage. UCC essential terms test. Under the UCC, essential terms include identification of the parties and goods, quantity, but not price. Mailbox rule. Acceptances are effective upon dispatch. In Florida, the mailbox rule does not apply to options contracts. Invitation to deal. There's a difference between an offer and a mere invitation to deal, which is typically a non-binding solicitation of interest. Advertisements usually do not constitute offers unless they are very specific with terms of how to accept, such as date, location, price, and manner of payment. When you encounter an essay where the parties are communicating back and forth, a good strategy is to highlight each correspondence chronologically and identify if it constitutes an offer, an acceptance, or something else like an invitation to deal or an advertisement. In addition to an offer and an acceptance, contract formation requires consideration. Consideration in Florida is a bargain for exchange of legal benefit or detriment. Essentially, consideration means that a person is promising to do something they weren't otherwise obligated to do, such as make a payment, perform a service, or refrain from doing an activity. Defenses. There's a difference between defense to formation and defense to execution. Successful defenses to formation would defeat a breach of contract claim because it can be shown that no contract existed. Examples of defenses to formation include statute of frauds, mistake, and duress. Defenses to execution, such as impossibility or frustration of purpose, recognize an otherwise enforceable contract, but under the circumstances, enforcement of the obligation should be legally relieved. The most common defense on pretty much every Florida contracts essay is a statute of frauds. Under the statute of frauds, there are certain contracts that must be in writing and signed by the party to be charged. These contracts include my legs. Contracts in contemplation of marriage, contracts that cannot be completed with 1 year, contracts for land, executorships, contracts for goods over $500, healthcare guarantees, and suretyships. Exceptions to the statute of frauds include swap, specially manufactured goods, written confirmatory memos, admissions in court, promissory estoppel, and partial performance. Written confirmatory memos require the essential terms, promissory estoppel alludes to detrimental reliance, and partial performance is common in land, payment, possession, and/or improvements, for example. And partial performance can also be satisfied under the UCC if the goods are delivered and accepted. Look to apply the statute of frauds to a fact pattern and then argue that an exception could potentially place the contract outside the requirements of the statute of frauds. As always, try to utilize the IRAOC formula and tease out your points. The next most common defense to argue is that there was a mistake, which can be either unilateral or mutual. A unilateral mistake will not void the contract unless the non-mistaken party knew the mistaken party's mistake and essentially took advantage of them. Otherwise, the mistaken party will bear the burden of the mistake. A mutual mistake occurs when both parties are mistaken as to the true terms of the contract or have attached conflicting meanings to essential terms. Due to the mistake, there was no true meaning of the minds, and the contract is voidable by either party. Appropriate remedies for mutual mistake are reformation to modify the contract to reflect the desired intent of the parties, or rescission to place both parties in the position they would have been before the contract was executed. After arguing the defenses of statute of frauds and mistake, you should consider the many other defenses to contract formation and execution. Notice that a lot of them start with the letter I. Defenses to formation include lack of consideration, fraud, duress, misrepresentation, undue influence, incapacity, including intoxication, infancy, maturity, and incompetence, illusory contracts, which are empty promises, illegality and unconscionability, which can be procedural and substantive. Defenses to execution include impracticality, impossibility, and frustration of purpose. Other contract defenses include unclean hands, laches, and acquiescence. Ultimately, it's not necessary to mention every defense in every essay, but it's certainly prudent to argue for and against the relevant ones. Statute of frauds, mistake, and impracticality come up often. Note the difference between impracticality and possibility, whether or not something can objectively be performed, and that foreseeability is a crucial element in impracticality. For instance, if it was foreseeable that the price of production would increase, it would be difficult to prevail under a defense of impracticality. Frustration of purpose occurs when the contract could be performed. However, the underlying purpose has been nullified. For instance, the bride and the groom break up before the wedding. The venue is still fine, but the purpose has been destroyed. It is important to note that destruction of subject matter or death of a party will render a contract voidable. A minor can void a contract and can ratify upon reaching maturity. There are certainly a lot of details involved with contract defenses, and essays should argue effectively for both sides regarding the viability of related defenses to formation and execution. Breach. The underlying claim for almost all contract essays is breach of contract. A breach can be material, which strikes at the heart of the agreement, and occurs when one side does not receive the benefit of the bargain of the contract. In this case, damages may be appropriate, including potentially rescinding the contract. An immaterial breach is a minor breach that does not significantly deprive either party of the benefit of the bargain and does not justify voiding the contract. One type of breach that is heavily tested in Florida contracts essays is an anticipatory repudiation, which occurs when one side unequivocally demonstrates an intent not to fulfill the obligations of the contract. When this occurs, the non-breaching party should request further assurances, which merchants have 30 days to respond to. A request may only be sent upon reasonable doubt of performance, and if an anticipatory repudiation has occurred, the non-breaching party may sue immediately or wait until the actual breach occurs to sue. A common form of breach under the UCC is a non-conforming shipment. Under the perfect tender rule, the delivery of goods must match the terms of the contract exactly. If a non-conforming shipment is, however, sent with a notice of accommodation, this will not constitute a breach but a counteroffer. A non-conforming shipment in response to a prompt shipment offer is an acceptance and a breach, unless it comes with a notice of accommodation. The perfect tender rule only applies to the UCC, as only substantial performance is necessary to fulfill the obligations of the contract at common law. Under common law, in order for there to be a modification, there must be consideration. However, between merchants under the UCC, a modification must only be made in good faith. Damages. Damages for breach of contract can be either legal or equitable. Legal relief is monetary and can be either compensatory or punitive, although punitive damages are very rare in contract law. The most common type of compensatory legal relief is expectation damages, which put the non-breaching party in the position they would have been without the breach. Consequential damages are damages that are foreseeable in light of a breach, and incidental damages are damages that arise as a result of mitigating circumstances. Lost wages, lost profits, reliance damages, and restitution damages are also forms of legal relief. One way to measure damages is the cost of cover, which is the cost of replacing the missing or non-conforming good at market price. A non-breaching party will always have a duty to mitigate whenever possible. Equitable relief is court-ordered and includes specific performance, injunctive relief, reformation, rescission, replevin, promissory estoppel, and enforcement of a quasi-contract. Specific performance is typical for land or unique goods, such as art, but is almost never appropriate for services, as this would equate to indentured servitude. Legal relief is the preferred remedy, and equitable relief is only appropriate when monetary damages would not suffice. I often tell essay writers to try writing the main points of damages before any other heading, even though it'll appear at the bottom of the essay. I remind students that the reader does not know how you constructed the essay, and since examinees often run out of time, it may be prudent to at least discuss the general differences between legal and equitable remedies quickly to start the essay, although physically placed below the rest of the essay, and then fill in the details later. I also recommend this approach with ethics. However, since there are many different considerations for different students, this is certainly not a strategy for everyone. Other issues. There are definitely some other issues that are often tested on Florida contracts essays that I didn't really get a chance to mention above. If you recognize these issues, you should certainly discuss them on an essay. Parole evidence. Oral evidence will not be admitted to contradict the fully integrated agreement. A contract shall be construed between its four corners. However, exceptions to the parole evidence rule include evidence of defects in information, conditions to performance, clarifications of ambiguous terms, and to show evidence of customs and terms of trade usage in the industry. Non-compete agreements. NCAs must be reasonable in geographic scope, subject matter, and duration. NCAs involving patents are limited to 5 years. NCAs under 6 months are presumed reasonable, and NCAs over 3 years are presumed unreasonable. However, NCAs, like all contract clauses, should be examined on a case-by-case basis. Liquidated damages. These clauses are included in contracts that calculate damages in advance that would be too speculative to calculate in the event of a breach. An example is a delay clause in a construction contract or a down payment for a boat rental. Liquidated damages clauses must be reasonable and cannot operate as a penalty. They should be limited to 20% of the contract value. Accord and satisfaction. An accord is an agreement to pay a lesser amount than owed, and satisfaction is the payment of this amount. Satisfaction will extinguish the original debt. Third-party beneficiaries. A TPB can be intended, named or ascertainable in the contract, or incidental, unintended. An intended third-party beneficiary has rights and can stand in the shoes of the original party to enforce the contract. The rights vest when they either detrimentally rely on the contract or sue on the contract. I must admit it's getting late. I will put this letter in the mail and look forward to your response. I am sure you have some follow-up questions. Remember, if this letter was an acceptance under the mailbox rule, it would be effective upon dispatch. Sincerely, Andrew. Dear Andrew, thank you so much for your letters. So helpful. I really appreciate all the points you mentioned. I will make sure to study them carefully. Are there any other suggestions you have for me in regards to writing an outstanding Florida contracts essay on the bar exam? SP. Stick boy. I think contracts essays are manageable if you can remember the BFD-BD format. When you're reading the prompt, take note of issue indicators. For example, if they mention the age or mental state of a party, it most likely indicates a capacity issue. If they mention an oral agreement, it will implicate the statute of frauds. If they say stick boy or noun painter and stick man, an owner of a notable art gallery, this likely indicates that the parties are merchants if the contract is for art. A statement that one party does not intend to honor the contract implies an anticipatory repudiation. The more you practice issue spotting, the clearer the issues become on the essays. Stick to the IRAOC formula and be diligent in defining legal concepts and applying them to the facts. If you would like to submit a sample essay, I'd be more than happy to grade it for you. AB. Dear Andrew, thank you so much. I'll work on writing some practice essays and I'll send them to you separately to grade. I was hoping we could move on to Torts after this. Me too, right? Happy holidays. Dear Stick Boy, it's been my pleasure to help you on the contracts. I look forward to answering your questions about the remaining subjects. On the topic of holidays, I was thinking about Rudolph today. His nose was always red. First, they made fun of him because of it. Then they praised him for it. Others should not dictate how you see yourself. Merry Christmas to you and your family, Stick Boy. Keep up the amazing work. You're going to crush this test. Andrew. Torts. Dear Andrew, thank you so much for grading my contracts essays. I finally feel good about that subject for the exam. Torts, on the other hand, well, that's a whole different story. What advice would you give a young stick boy like me when it comes to writing a Florida torts essay? Dear Stick Boy, It was a pleasure to grade your contracts essay. They are fantastic, especially your discussions on the battle of the forms provision, the non-compete clause, and the different forms of legal and equitable relief. You should have recognized that contracts is almost always tested with ethics or professionalism, and sometimes in conjunction with torts, property, family law, or even con law. Torts is actually my favorite subject in the bar exam. I remember when I was a 1L and first saw my class schedule, I had never seen the word tort before. I ended up receiving the Cali Award for the highest grade in my class. Every time I've sat for the bar exam, I've always scored the highest on torts. I think the reason I excel in this subject is because although the word tort was originally foreign to me, all the subjects were innate. I grew up with 2 older brothers, and therefore I've been on the receiving end of my fair share of assault, battery, and infliction of emotional distress, as well as trespass to my room, conversion of my favorite toys, invasion of all my privacies, and slander to my parents and friends. I was also mentored by my grandfathers, Joe Reisman and Sam Dennis, who were lifelong attorneys. Both of them were known as reasonable men. For instance, if there was a dispute amongst the grandchildren, justice would always be apportioned fairly. Between my grandparents teaching me reasonableness and prudency, the standards for negligence, and my brothers intentionally putting me in headlocks, assault, battery, IID, false imprisonment, I had the best pre-law school experience for learning torts. And with my dogs always being a nuisance, torts is just an everyday part of my life. Luckily for you, Stick Boy, I can help you master torts without any physical pain. Of course, you would have been lucky to have met my grandparents, but hopefully I can carry on their wisdom. The task of the examinee in a torts essay question usually involves assigning blame to a party based on negligence or intentional harm. Your job is to effectively argue for both sides and to inform the reader of as many plausible claims as possible, even if they are weak and easily defeatable. I refer to this as the kitchen sink method and encourage you to write an RAOC for each claim you identify. I will answer any questions you have, but I want to first express that torts is a subject you can excel in by using your common sense and by looking at the fact pattern from a bird's eye view to assign liability to the tortfeasors and compensate the parties that have been wrong for their losses. Whenever I encounter a torts essay, I like to think of the arguments of an ambitious personal injury attorney and then consider the likely defenses of a heartless insurance company. I hope this letter serves as a solid segue into any specific questions you have regarding Florida torts essays. Looking forward to your response, Andrew. Dear Andrew, thank you for your letter. Your grandparents sound wonderful. Your brothers sound tortuous and torturous. All jokes aside, I'm really struggling with torts. Are there any key points I should know? SP, I'm so glad you asked me this question, as I think there are 3 things you should absolutely mention on every torts essay. As of 2023, Florida is a modified comparative fault state. This means that Florida recognizes contributory negligence as a viable defense. However, a plaintiff that is greater than 50% at fault is barred from recovery. Florida has abolished joint and several liability. This means that a plaintiff must seek damages individually from each defendant for the respective proportion of liability. In Florida, punitive damages for negligence are limited to 3 times compensatory damages or $500,000, whichever is greater. There are some exceptions, such as abuse to the elderly, where this cap does not apply. I cannot overstate the importance of mentioning these 3 things in every torts essay. They should be mentioned even if you think they don't apply. If they clearly apply, you should go into a detailed analysis using an IRAOC method. Let me know if any questions, AD. Andrew, got it. I will make sure to mention on every Florida torts essay that Florida is a modified comparative fault state, that Florida has eliminated joint and several liability, and that punitive damages are limited to the greater $500,000 or 3 times compensatory damages for negligence. I feel like there are so many different torts. Do you know which ones are most heavily tested on Florida torts essays? Stick Boy. Dear S, negligence is tested on pretty much every torts essay. To spot negligence, just look out for someone did something stupid and deviated from the standard of care. There are a lot of different types of negligence, such as negligent infliction of emotional distress, negligent supervision, negligent hiring, negligent training, negligent design, and negligent entrustment. While negligence is almost always a guarantee to be tested, the other torts that are most heavily tested seem to be defamation, products liability, and premise liability. Common sub-issues are assault, battery, NIED, IED, and invasion of privacy. What else can I help you with? Andrew. Dear Andrew, Happy New Year. I hope you have had fun plans for tonight to celebrate 2024. I really like the way you broke down all the headings for a contract essay. I was hoping that you could do the same for me for torts as well. Wishing you and your family well to ring in the new year. Stick Boy. Dear Stick Boy, same to you and yours. Today is 12/3/123. 123/123. With that in mind, I'll try to break down torts essays as easy as 1, 2, 3. Remember to try to throw the kitchen sink at the reader and identify as many viable or seemingly viable claims as possible. 3 points on every Florida torts essay. Florida is a modified comparative fault state. Florida has abolished joint and several liability. Punitive damages are limited, 3 times compensatory damages or $500,000 for negligence. Negligence. A claim of action for negligence requires a duty, breach, causation, and damages. Let's look into each of these. Duty. A duty of care is established by determining how a reasonably prudent person under similarly situated circumstances should act. A child has the duty to act as a child of similar age, intelligence, and sensibilities, but will be held to an adult standard of care for adult-like activities such as driving a boat or a car. Florida recognizes the Good Samaritan rule, which protects rescuers from liability as a result of rescue efforts. A person who negligently puts themselves in a situation that invites danger can be held liable for injuries to a foreseeable rescuer. An exception is the firefighter rule, which applies to policemen, firefighters, and other professional rescuers who assume a risk of injury in the course of their rescue work. An expert will be held to a heightened standard of care, but an amateur will not get a reduced standard of care when engaging in activity. Doctors are typically held to a national standard of care, while more localized professionals should be held to a regional standard of care, such as hurricane shutter installers in South Florida. There are other ways duties can attach besides the reasonable person analysis, including negligence per se, vicarious liability, res ipsa loquitur, and strict liability. Negligence per se is when a statute or ordinance, either civil or criminal, establishes a duty of care, such as a speed limit ordinance. It is important to note that negligence per se only applies if the injury that occurs is the type of injury contemplated by the statute and the class of people it's designed to protect. For example, a no parking ordinance next to a fire hydrant is designed to protect people from fires, not other drivers who hit the car. Serving alcohol to a minor in violation of a statute is a classic example of negligence per se. For example, if the minor gets into a drunk driving accident and causes damages to another driver, this is the type of injury the statute was designed to protect. Vicarious liability is when a third party can be held liable for the negligence of another, when one party is acting as an agent of a principal or there's a master-servant relationship. A parent will not likely be held vicariously liable for the acts of their children, but could be found liable for negligent supervision. An employer can be held liable for the acts of its employee under the theory of respondeat superior. An employee will not be liable for negligence that occurs during a frolic outside the scope of business, but will be liable for acts that occur during a detour, such as a delivery driver getting coffee on his route. Employers would generally not be held liable for intentional torts of employees unless it is inherent to the job, such as assault and battery for a bouncer. In some situations, a party will be said to have a non-delegable duty, such as a mall maintaining a safe premises, and some dangers are too open and obvious to require warning, such as warning that a tree could be walked into. The concept of res ipsa loquitur means that thing speaks for itself and applies to situations where a party has exclusive control over an item or instrumentality, such as a falling pot off a balcony or a scalpel left in an organ by a doctor. The circumstances around the accident leave no room for alternative explanation other than the negligence of whoever was in exclusive control of what caused the injury. In Florida, strict liability applies to prox liability, inherently dangerous activities, and wild animals. Florida has also abolished the one-bite rule for dogs, so a dog owner will be held strictly liable for dog bites, regardless of whether or not the dog was known to be aggressive or had a history of dog bites. In the earlier example of a store owner selling alcohol to a minor, some states consider this strict liability, so it'll be worth arguing, although negligence per se under the state statute will probably be more appropriate. Strict liability in tort law essentially means absolute liability in the sense that it's not necessary to prove fault or wrongful behavior, since there are no viable defenses for the act itself. Keep in mind when discussing on a torts essay that you do not need to discuss all the considerations above. Supra. Rather, you need to identify whether the defendant had a duty and establish the appropriate standard of care under the circumstances, and whether or not the accused tortfeasor had any reason to act or refrain from acting. Ultimately, proving that a party had no duty is the quickest way to defeat a negligence claim. For example, if an unknown trespasser gets injured by a rotten tree on a property, the property owner should not be liable since she did not owe the unknown trespasser any duty of care. Breach. The second element of a negligence claim is a breach, which is simply a deviation from the applicable standard of care. Swerving in traffic would be a breach of the duty to drive safely, allowing your kid to run naked at the zoo, which would be a breach of the duty to supervise your child, and a mechanic failing to tighten the lug nuts on a tire would be a breach of his professional duty. The breach is usually easy to identify, and if possible, you should argue both sides as to whether a breach occurred. Causation. There must be actual, but for, and proximate cause within the zone of danger / foreseeable plaintiff. Actual cause is satisfied if the injury would not have occurred but for the breach. Proximate cause establishes that the injured party was a foreseeable plaintiff, per Justice Andrews, or within the zone of danger, per Justice Cardozo. A superseding event is an event that relieves liability from the original tortfeasor because it breaks the chain of causation, such as an intentional crime by a third party. An intervening event may contribute to liability, but does not entirely relieve the original tortfeasor of liability. If there's an intervening or superseding event, this is a good time to discuss modified comparative negligence and the abolishment of joint and several liability. Contribution is proper when there's an intervening event or comparative fault, and liability can be allocated proportionally, whereas indemnity is proper when there's a superseding event or a complete shift of liability from one party to another. Damages. Florida recognizes civil damages in the form of compensatory damages and punitive damages. Compensatory damages include pain and suffering, emotional distress and mental anguish, medical expenses, loss of wages, diminished earning capacity, loss of consortium, abode share one's company, and out-of-pocket expenses. It is important to note that for prox liability cases, Florida follows the economic loss doctrine, which states that a plaintiff cannot recover for purely economic losses, since that would more properly constitute a breach of contract claim. When discussing damages for negligence, remember to discuss the 3 times $500,000 cap on punitive damages, which are designed to punish defendants for willful or wanton behavior. When discussing damages, you should try to mention the available damages, while also discussing which damages would not be available. For instance, a claim for lost wages for a job a person who is applying for but has not secured a job would probably be too remote to constitute measurable damages. For all types of civil damages, Florida recognizes the eggshell plaintiff theory, which means that a defendant is liable for all of the plaintiff's damages, no matter how susceptible a plaintiff is to injury. Negligence is the proper cause of action when someone deviates from the proper standard of care. They do something stupid. Many claims are rooted in negligence, such as premise liability, malpractice, and wrongful death. I will discuss these claims separately below. Buzzwords to look out for are employer-employee relationships, which signify responding its superior, statutes defining duty of care, which alert us to negligence per se, and rescuer situations remind us of the Good Samaritan rule. Defenses to negligence include comparative fault, assumption of risk, res judicata, collateral estoppel, claim preclusion, issue preclusion, and statute of limitations, which as of 2023 is 2 years from the accrual of the cause of action. Of all the types of negligence, NIED seems to appear the most. NIED requires that the plaintiff must suffer physical injury. The plaintiff's physical injury must be caused by psychological trauma. The plaintiff must be involved in some way in the event causing the negligent injury to another, and the plaintiff must have a close personal relationship to the directly injured person. There are some exceptions to requiring physical injury, which is known as the impact rule, including negligent mishandling of a corpse, inaccurate disclosure of an HIV test, claims involving wrongful birth such as stillborns, defamation, and invasion of privacy claims. Florida courts have consistently relaxed the need for physical impact and recently modified the impact rule in bystander cases by excusing the lack of a physical impact. In such cases, recovery for emotional distress would be permitted where one suffers death or significant discernible physical injury when caused by psychological trauma resulting from a negligent injury imposed on a close family member within a sensory perception of the physically injured person. Under Florida dram shop laws, a person who sells or furnishes alcohol, like beverages, to a person of lawful drinking age shall not thereby become liable for injury or damage caused by or resulting from the intoxication of such person. As mentioned in my previous letter, there are many types of negligence, including negligent hiring, supervision, training, entrustment, and design. I think it is almost impossible to write a torts essay without doing a negligence analysis, so please make sure to at least memorize the elements of duty, breach, causation, and damages. Intentional torts. You must prove intentional conduct, not just merely negligent conduct. Assault is intentionally placing someone in the reasonable apprehension of imminent battery. It is not possible to assault a sleeping person, as they must be aware of the assault. Assault and battery claims usually are brought together, although assault without battery occurs when there is no offensive touching, for instance, a punch that doesn't land. Battery is intentional offensive touching of another. Battery is a dignity tort, so damages are presumed and no injuries need to be shown. For instance, striking a person is battery, even if the person does not suffer any physical injuries. A common defense to battery is consent, such as in a boxing match. Another defense to battery could be self-defense or defense of others. Whether this defense is valid depends on whether or not the use of battery was objectively reasonable under the circumstances. False imprisonment occurs when someone intentionally confines another without justification. The defendant must be aware of the confinement while it's occurring, not after the fact. The shopkeeper's privilege allows store owners to temporarily confine a suspected shoplifter only for the period of time necessary to confirm whether or not the person has stolen anything. Another defense to false imprisonment is necessity, such as a citizen's arrest or locking an enraged drunk person in a room who is threatening to hurt people. Trespass to land is the intentional intrusion upon the property of another. It can be actual intrusion by a person, such as walking on the property, or it can be intrusion by an object, such as a rock that is thrown onto a property. Trespass is similar to battery in the sense that the act alone satisfies the intent element of a claim, regardless of the reason for the trespass or whether there are physical damages. For instance, if a person walks on his neighbor's property, but mistakenly believes it is his own property, this still constitutes actionable trespass because the person intended to walk on the property, even if he did not intend to trespass. A common defense to trespass is necessity, such as the need to do an emergency helicopter landing on a farm or to dock a boat during a severe weather storm. Another consideration of trespass is the attractive nuisance doctrine, which treats children as invitees instead of trespassers if there's a feature of the property that is luring to the children and causes harm. For instance, a property owner can be held liable for injury to a child who trespasses and gets hurt playing on a broken trampoline. Trespass of chattels is the intentional deprivation of the use of another's property. An example of trespass of chattels is borrowing your neighbor's chainsaw without permission and returning it later, having deprived them of the use of their possession. Conversion occurs when the trespass from their property results in the loss of the use of the property. For instance, if you borrowed your neighbor's chainsaw without permission and it breaks, this constitutes conversion and you will be liable for the cost of replacing the saw. It should be apparent that trespass of chattels and conversion are civil equivalents to theft crimes. IIED is the intentional causing of emotional stress in another through outrageous behavior. The plaintiff must prove the defendant engaged in intentional reckless conduct, the conduct was outrageous, the conduct caused emotional distress, and the emotional distress was severe. An example of IIED is a man painting racial epithets on his neighbor's home. Malicious prosecution is the act of intentionally causing irritation in someone's life through meritless litigation. Intentional endangerment is intentionally placing someone in a dangerous situation. Reckless driving is intentionally driving in a malicious manner. Defenses to intentional torts include consent, self-defense, and defense of others, necessity, statute of limitations, res judicata, claim preclusion, and collateral estoppel, issue preclusion. Other torts. These torts have elements of either negligence, intent, or both. They are often tested and must be memorized. I know I said easy as 1, 2, 3, but why not go for 4? Defamation. Defamation can be slander, spoken, or published, libel, and requires dissemination of false material to a third party that is injurious to another's reputation. Truth is an absolute defense of defamation. Another defense is privilege, such as defamation in a letter requested by a former employer or defamation of another legislator, protected under the Constitutional Speech and Debate Clause. There's an important distinction between a private plaintiff and a public plaintiff / matter of public concern because a private plaintiff needs to only prove negligence, whereas a public plaintiff needs to prove actual malice, that the statement was knowingly false. In Florida, to sue a media defendant such as newspaper, the plaintiff must provide notice within 5 days of the publication of the statement, and the media defendant has 10 days to retract the statement to avoid further damages. Florida recognizes slander and libel per se, which we can remember using the club mnemonic. Defamation involving crimes of moral turpitude, loathsome diseases, unchastity, and business. For these types of defamation, damages are presumed. Defamation is heavily tested because it has the constitutional First Amendment implications as well, since it is categorized as unprotected speech from government intrusion. Invasion of privacy. Florida does not recognize a separate tort for false light because of the similarities to defamation. However, Florida recognizes the privacy torts of intrusion upon seclusion, appropriation, misappropriation, and public disclosure of private information. Intrusion upon seclusion is the intentional invasion of someone's privacies. Appropriation is the unauthorized use of someone's likeness, and public disclosure is when someone intentionally reveals another's private information. Premise liability. This is essentially a negligence claim since the plaintiff must prove the elements of duty, breach, causation, and damages. A property owner owes the highest duty of care to invitees, followed by licensees, then known trespassers, and finally unknown trespassers. A property owner has a duty to maintain safe premises for invitees and licensees and to warn of known dangers or dangers they should know about that invitees or licensees should be unaware of. Florida distinguishes between public invitees, park visitors, and business invitees, shoppers at a store, and also between invited licensees, social guests, and uninvited licensees, a door-to-door salesman. Only uninvited licensees are not owed a duty to warn, although property owners may not enforce any willful or wanton injury upon an uninvited licensee, such as a concealed trap. No duty to warn is owed to unknown trespassers, although again, property owners may not have concealed traps for the purpose of inflicting wanton injury on others. The only duty owed to known trespassers is to warn of known duties that are not open and obvious if observed. In a Florida Torts essay, look out for a situation where a licensee or invitee exceeds the scope of their privilege, opening a door marked employees only, and how their status arguably has changed from an invitee to a trespasser. Products liability. Products liability can be argued under a theory of strict liability or negligence. Both theories should be argued in an essay. The plaintiff must show that a commercial supplier, a manufacturer, distributor, producer, wholesaler, retailer, placed a defective product in the stream of commerce and there were damages. Damages to the product itself do not constitute actionable damages under the economic loss theory. There must be damages to a person or property. Under strict liability, any downstream party can be held liable so long as the product was defective when it left their hands, even if they were not responsible for causing the defect. The four types of strict liability theories are express warranties, failure to warn, inadequate warning, implied warranties of merchantability and fitness for a particular purpose, design defect, and manufacturing defect. Some warnings are not necessary because the danger is open and obvious, but this should be argued in an essay. Merchantability requires a product to function generally, and fitness for a particular purpose refers to a warranty for a specific use. A design defect occurs when the product was designed in an unreasonably dangerous manner, utilizing the risk utility balancing test and considering whether or not there were safer alternative designs. A manufacturing defect occurs when a product is made differently than designed, such as a part getting affixed incorrectly on the assembly line. A rarely tested concept regarding strict liability is the market share liability theory, which allows a plaintiff to assign liability proportionality to each manufacturer of a fungible good, such as a pharmaceutical drug. To assign liability proportionally to each manufacturer of a fungible good, such as a pharmaceutical drug. It is important to note that whenever there's a strict liability argument for products liability, there's a contemporaneous argument for negligence. It was negligent to design, manufacture, or fail to warn, for example. The difference between negligence and strict liability is that defenses such as comparative fault or assumption of risk will not apply to strict liability. Wrongful life. Florida does not recognize a tort for wrongful life. Wrongful birth. Florida does recognize a tort for wrongful birth, which is brought by the parents against a medical professional for failure to disclose the health problems of an unborn baby. Wrongful death. This claim is a civil version of manslaughter. Essentially, the negligence of a person resulted in the death of another. Wrongful death claims are brought by the survivors of the deceased, the estate, and damages include loss of present and future support. Survivorship claims. These claims are also brought by the estate, but they differ from wrongful death claims because they do not provide relief for the death of the decedent, but they allow the survivors to pursue any lingering tort or contract claims the person may have had before they died. Medical malpractice. In order to bring a medical malpractice claim in Florida, the plaintiff must provide notice to the defendant and also have the claim verified by an independent third party as viable. Types of medical malpractice claims include failure to diagnose, surgical errors, wrong medications, and missed laboratory results, among others. The accused has a right to choose either mediation or arbitration, and if arbitration is chosen, there are caps on non-economic damages. Nuisance. Nuisance is an unreasonable disturbance. A private nuisance claim is brought by a private party against another private party, while a public nuisance claim is when the disturbance is annoying to the community at large and is usually brought by the Attorney General. Examples of nuisances are noxious odors, loud music, or continuous barking of a dog. A common defense to a nuisance claim is that the person bringing the claim is unusually sensitive. For instance, someone who is nocturnal will likely fail in a nuisance claim against his neighbor for daytime child's play noises, as it is unusual to be sensitive to noise during the day. Speaking of nuisance, it's getting close to midnight and the fireworks are starting to go off, and my dogs, the notorious neighborhood nuisances, are getting anxious. I think I'm going to take them to the park to enjoy the fireworks. Although fireworks are not typically seen as an abnormally dangerous activity that would invoke strict liability, the essay could have a statute that defines fireworks displays as abnormally dangerous, or it could have a statute that would make mishandling of fireworks actionable per se. While lighting fireworks on New Year's Eve or 4th of July should not constitute a nuisance, it arguably could on any other night. I want you to start looking at all scenarios as potential torts claims. Anyway, I'm off to walk the nuisances and ring in the new year. Cheers, Stick Boy. Happy New Year to you and your family. Andrew. Andrew, I just read your letter to start the new year. My head hurts from last night, but not from drinking, from diligently studying the Florida law. Thank you so much for your letter. It is great for me to be able to refer to all the torts. Is there anything else you think is important for me to know about torts? Stick Boy, I love the new year. My top 3 resolutions are to get better at chess, boxing, and Spanish. What are yours? The main thing when it comes to torts, not to sound like a broken trampoline or broken record, is to throw the kitchen sink at the reader. I often give my class the example of my neighbor throwing a rock at my head and saying Ibis prep tutors are dumb. The obvious claims are assault and battery. There's also a claim for trespass as he threw a rock onto my property. Furthermore, there are potential claims for IAD and NID because of the outrageous behavior and the fear I will now have of opening my door. Lastly, his comment could amount to slander per se if any of my neighbors heard him because he was stating harmful material about my business. The point is that anytime someone is injured or suffers losses, there are multiple theories of liability. It is your job to be creative and identify as many relevant claims as possible, utilizing the IRAOC method. I highly recommend that you write essays for me to grade, and also that you read every torts essay prompt and model answer for the last 20 years. Good luck and keep up the great work. AD. Andrew, my New Year's resolution is to go to the gym. I'm tired of looking like a stick. I was there today and couldn't help but think of all the potential claims that could arise at the gym. You would have been proud of me. Thank you for helping me, and I'll send my torts essays right away. Stick Boy. The big one. Con law. Dear Andrew, the big one. Thank you for grading my torts essays. I took your advice and compared my essays to the FBB model essays. They are so well written, but I understand they are model answers and that I'm trying my best to emulate them. I've read every single torts and contracts essay prompt and model answer and have memorized the questionnaires you gave me. I feel really confident about those 2 essay subjects, but I'm anxious about the remaining ones, especially con law and property, rightfully so. The more I think about it, the more overwhelmed I feel. Oh no. Do you think you could help me? Stick Boy. Dear Stick Boy, I'm glad that you're starting the new year with confidence. Contracts and torts are heavily tested subjects, and you should be proud of yourself for your hard work. Con law and property are notoriously difficult essay subjects, but I'm here to help you learn them properly. Let's start with con law. Do you have any questions for me in particular? Dear Andrew, I think I'm confused in general about how con law is tested in the Florida bar exam. Do they test federal con law or just Florida con law? Why are there model essays labeled con crim law? When it comes to con law, I'm as nervous as a long-tailed cat in a room full of rocking chairs. S. Dear Stick Boy, I'm happy to help you clarify and not feel like such an unfortunately positioned cat. You should understand that con law can be tested through 3 different lenses: the Florida lens, the federal lens, and the criminal justice lens. Constitutional law is tricky because mastery of it requires an understanding of the complex history of our nation states, and the Sunshine State is especially eclectic. The Florida lens includes issues such as homestead exemption, the Sunshine Law, home rule power, requirements for enacting laws, special legislative sessions, and the separate yet connected roles of the governor, the judicial legislative branches, as well as constitutional officers such as sheriff or a mayor. The federal lens requires you to understand the implications of the first 16 amendments to the Constitution, as well as important concepts such as fundamental rights and levels of scrutiny, due process, equal protection, the Commerce Clause, the Anti-Commandeering Clause, standing, justiciability, vagueness, overbreadth, and separation of powers. The criminal lens is mostly focused on the 4th, 5th, and 6th Amendments, especially the issues of warrants, probable cause, reasonable expectations of privacy, the exclusionary rule, and the fruit of the poisonous tree doctrine, as well as the concepts of custody, interrogation, and Miranda rights. They may also test elements of Florida criminal law, such as murder, arson, conspiracy, and theft. I've been swamped working in and on my business. When I find the time, I'll be happy to sit down and write a letter with details about all of the testable topics in con law if you would find that helpful. Thank you so much and keep up the good work. Dear Andrew, thank you for writing these letters. I appreciate you taking the time away from your students and running your business to help me. I would be extremely helpful if you could write me a detailed letter to refer back to me for con law. After I pass the bar, I'll make sure to support you and your business. Maybe I'll set up a Stick Boy scholarship fund. With gratitude, Stick Boy. Stick boy, as I told my father when he texted my family group chat, using all caps is a criminal offense punishable by jail time. Just kidding, please do not write that in bar essay. I'm happy to break down con law essays for you. The one similarity amongst all con law essays is that there will be some sort of state action, because the rights guaranteed by the US and Florida constitutions generally apply to state action, not private action. The most common way this is tested is through a legislative act or ordinance requiring you to analyze its constitutionality. I'm going to start with the key federal concepts that can almost always be mentioned on any con law essay. State action. The Constitution protects intrusion upon individual rights from government action. Actions by private entities are mostly excluded from the ambit of the Constitution, except in exceptional circumstances such as the 13th Amendment, or if the state is sufficiently intertwined with private activity to justify commercial protection. Standing. In order for a plaintiff to have standing, she must show causation, injury, and redressability. Third-party standing is rare, but is appropriate when a plaintiff cannot assert her rights on her own and there's a close relationship between the plaintiff and the representative. Organizational standing occurs when an entity sues on behalf of its members. Justiciability. In order for a case to be heard, the matter must be ripe and not moot. Ripeness means that the case is sufficiently developed. It is not too early. And mootness means that the issue has already been resolved. It is too late. A matter is not ripe if the act or ordinance has not been passed yet, for example, and a matter would be moot if the project undertaking that is contested was already completed, like the building of a bridge. An issue is not moot if it is repetitive and capable of evading review, such as allowing handicap access for bar takers. The bar is administered twice a year, or a pregnancy claim. People can reproduce human art every 9 months. Courts will also refuse to hear political questions, although this concept is mostly applicable to Supreme Court, has never been tested in a Florida essay so far. Con law and property are significantly more difficult than torts or contracts because there are so many different ways they can test the numerous subtopics, and there isn't as reliable of a blueprint. For con law specifically, you can almost always begin by addressing state action, standing, and justiciability. However, after that, there are many different paths, and your job is to be well equipped with constitutional arguments and apply the relevant ones to the fact pattern. In regard to federal law issues, I've ranked and defined the following concepts in order of likeliness to be tested on an essay. Fifth Amendment due process. Always remember that there are 5 important parts of the Fifth Amendment: due process, taking, right against self-incrimination, Miranda rights, and double jeopardy. The Fifth Amendment due process rights apply to infringements by the federal government, but has been incorporated to the state through the 14th Amendment. Procedural due process requires notice and hearing before the government can deprive an individual of a life, liberty, and property interest. Examples of recognized areas of due process interest in Florida include personal belongings, realty, chattel, money, public education, and welfare benefits. Whereas procedural due process refers to the rules the government must follow, including notice and hearing, substantive due process refers to the actual intrusive policy. Substantive due process is a deprivation of everyone's rights, while equal protection is when a specific group or class is targeted. Equal protection. The 14th Amendment guarantees equal protection and prevents any state from depriving any person equal protection of the laws. Florida specifically recognizes that no person shall be denied of any right because of race, religion, national origin, or physical disability, the suspect classes, unless the government can survive a strict scrutiny test. In essence, the government must treat all people the same. Laws that target gender are subject to intermediate scrutiny, while all other laws, including those targeting wealth, age, or just incidentally impacting a suspect or quasi-suspect class, are subject to rational basis review. First Amendment freedom of speech. The freedom of speech is a fundamental right guaranteed by the First Amendment of the Constitution. Content-based restrictions, such as a law prohibiting the display of signs critical of a government policy, are presumed unconstitutional and are subject to strict scrutiny, and the government must show the regulation is necessary to achieve a compelling interest and is narrowly tailored. Content-neutral restrictions, such as zoning laws regulating the operation of strip clubs to a certain part of a city, are subject to time, place, and manner restrictions and a heightened form of intermediate scrutiny. Specifically, content-neutral based restrictions must be necessary to achieve an important government interest and leave alternative means of communication available. To evaluate a government restriction on speech occurring on public property, courts must determine how the regulated area fits into the following categories of forums: traditional public forums, designated public forums, limited public forums, and non-public forums. Traditional public forums, like a sidewalk or park, are subject to time, place, and manner, content-neutral restrictions, which are a heightened level of intermediate scrutiny. A designated forum, like a university auditorium or municipal theater used for expressive activity by the public, are subject to the same restrictions as traditional public forums, but only while holding itself out as a public forum during that designated time. A limited public forum, public school facilities open after school, the interior of City Hall, a forum open for expressive activities but with restrictions to access based on subject matter and or speaker, must be viewpoint neutral. Viewpoint neutral is a less stringent standard than content neutral because the content of the discussion can be restricted to abortion, for example, but the viewpoint, pro or anti, cannot be restricted. Non-public forums, prisons, military bases, interior polling places, mailbox of public school employees and airports, the governor has much more flexibility to limit speech so long as the restrictions are reasonable and viewpoint neutral. Unprotected speech includes hate speech, words likely to incite imminent loss activity, obscenity, false or misleading commercial speech, and defamation. Obscenity appeals to the prurient interests of humanity and is devoid of any social or artistic value. First Amendment freedom of religion. There are 5 fundamental rights guaranteed by the First Amendment, including freedom of speech, freedom of religion, freedom of petition, freedom of association, and freedom of the press. Let me say it again. Freedom of speech, freedom of the press, freedom of petition, freedom of association, and freedom of religion. Freedom of religion includes freedom of association and free exercise. Religion is merely a sincerely held belief. Laws targeting religion are subject to strict scrutiny, while laws that incidentally affect religion in a non-discriminatory manner are subject to rational basis. For example, courts upheld laws banning peyote, even though it was used in practice by native religion since it was non-discriminatory, but struck down a law targeting religion's use of animal sacrifice as discriminatory. As of 2022, the historical lemon test has been abrogated as the courts permit a football coach at a public school to lead prayer to his team after games. Fundamental rights. The following rights are considered fundamental in Florida. The right to be free from laws targeting race, alienage, national origin, or disability, the right to contraception, the right to marriage, the right to procreate, the right to educate your child, and the right for parents to have a role in the upbringing of their children. Mnemonics to help memorize the aforementioned rights are Rand and Camper. The right to abortion is no longer considered a fundamental right in Florida. Additional fundamental rights include the right to travel, the right to vote, the right to work and join a union, the right to privacy, the right to be a candidate, the right to be free from governmental takings, access to courts, procedural and substantive due process rights, the right to bear arms, the right against unreasonable searches and seizures, the right to counsel in certain circumstances, the right against self-incrimination, the right against double jeopardy, the right to a speedy trial, the right to confront witnesses, and the right to trial by jury in certain circumstances. Access to courts. The Florida Constitution guarantees that the court shall be open to every person for redress of any injury, and justice shall be administered without sale, denial, or delay. Be on the lookout for a law or ordinance that requires posting a bond, paying money in order to go to court, or a law that has a clause restricting options for seeking relief. While access to courts is a fundamental right subject to strict scrutiny, it is important to note that under the Kluger Doctrine, certain fundamental rights, including access to courts, can be restricted if there's an overarching public purpose. One potential example is restricting access to courts during a pandemic for health concerns. The Kluger Doctrine should always be mentioned to support a counter-argument against an argument for denial of access to courts. Scrutiny levels. When there's an equal protection issue targeting a specific group of people, there are 3 main judicial scrutiny levels to consider. Under strict scrutiny, the government has the burden to prove the state action is narrowly tailored to achieve a compelling government interest. Strict scrutiny applies to deprivation of fundamental rights. Intermediate scrutiny requires the government to prove that the state action is substantially related to an important government interest and applies to sex-based classifications, illegitimacy issues, and restraints on commercial speech. Heightened intermediate scrutiny applies to content-based time, place, and manner restrictions, as it requires the government to show that the state action is necessary to achieve an important government interest and that leaves open alternative means of communication. Rational basis scrutiny places the burden on the plaintiff to show that the state action is not reasonably related to a legitimate government purpose. Rational basis applies to everything except for fundamental rights and to actions affecting suspect classes and quasi-suspect classes. Examples include regulations targeting age, wealth, teachers, or garbage workers, for example. It is very difficult for a plaintiff to show that the government action is not legitimate and rational. The term rational basis with bite has been used when it can be shown that the government acted with animus towards the challenging party, and has usually been used by courts for cases involving discrimination based on sexual orientation. Vagueness. A law is constitutionally vague if a reasonable person would not understand what type of behavior is being punished. Some courts have held that laws banning loitering, for instance, have been struck down because it is not clear what exactly is prohibited. Laws targeting speech are vague if a reasonable person cannot distinguish between permissible and impermissible speech because of the difficulty encountered in assigning meaning to language. Overbreadth. A law is overbroad if it reaches beyond the scope of the subject matter it was originally intended to cover. As applied to speech, a law is overbroad if it restricts more speech than intended. For instance, a law banning four-letter words at public schools would ban intended curse words, but would be overbroad for banning other words like duck and spit. Separation of powers. The separate branches of government on all levels, including local, state, and federal, are vested with certain powers that cannot be encroached upon or usurped. The executive branch executes the laws, the legislative branch proposes the laws, the judicial branch serves as the final arbiter and determines the constitutionality of the laws. It is improper for any commingling, entanglement, or entwinement between their respective branches. On the federal level, the executive branch has veto power, the power to enact laws, the power to exclusively represent the country in foreign affairs, treatise power, and the power to act as commander-in-chief, appointment and removal power, pardon power, and the power to make the State of the Union address. Congress has the power to propose laws, to tax and spend, to regulate commerce, to impeach, to enact legislative apportionments, and declare war. The judicial branch interprets the laws and subjects them to judicial scrutiny. Takings eminent domain. Under the Fifth Amendment, private property cannot be taken for public use without just compensation. A possessory taking occurs when the government physically invades the property, and a regulatory taking occurs when the government regulation renders a property either economically unviable or deprives the property owner of investment-backed expectations. Condemnation occurs when the government offers just compensation for a taking, and reverse condemnation occurs when a private property owner seeks just compensation from the government for an alleged takings. 10th Amendment states sovereignty. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. This means that states have police power and can enact laws that are not preempted by federal law. 11th Amendment sovereign immunity. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. This means that individuals cannot sue the state except state officers in their official capacity or if the state consents. Florida has waived sovereign immunity for tort claims involving operational decisions, but not planning decisions. Running a parade is an operational, whereas directing what route it goes down is a planning decision. Commerce Clause. Under the Commerce Clause, Congress can regulate the channels, instrumentalities, and economic activities that in an aggregate have a substantial effect on interstate commerce. The Dormant Commerce Clause. States cannot enact legislation that discriminates against interstate commerce on its face or unduly burdens interstate commerce. Privileges and Immunities Clause. States cannot discriminate against out-of-staters. For instance, it would be unconstitutional to charge more for commercial fishing licenses for non-residents than for residents. Anti-Commandeering Clause. Under the 10th Amendment, Congress cannot compel states to enact legislation, like a no-gun law in school zones, but they can induce them through conditional funding, not paying for highways unless states agree to drinking age requirements. Ex post facto law. An ex post facto law is one which renders an act punishable in a manner in which it was not punishable when it was committed. Contracts Clause. Under the Contracts Clause, state regulation must not substantially impair a private contractual relationship unless the state has a significant and legitimate purpose behind the regulation, such as the remedying of a broad and general social or economic problem, and the law must be reasonable and appropriate for its intended purpose. A heightened level of scrutiny is applied for situations where laws modify the government's own contractual obligations. Bill of Attainder. A bill of attainder is an act of legislature declaring a person or a group of people guilty of some crime and punishing them, often without a trial. Double jeopardy. A person cannot be tried for the same crime twice. Double jeopardy is a criminal equivalent of res judicata or claim preclusion. Jeopardy attaches in a jury trial after the jury has been impaneled and a bench trial after the first witness has been sworn in. I've also ranked the following federal common law issues in order of likelihood to appear on an essay. There are some issues that overlap due to complicated interplay between federal and state law. Ultimately, you should be prepared to write about all the issues using the framework of both the federal and Florida Constitution. Sunshine Law. Under the Florida Constitution, the Sunshine Law provides that public bodies are required to publicize all governmental activity and discourse. This law serves as a right of access for the people and ensures that legislation is conducted in the sun for all to see. There is exemption for unplanned meetings between two legislators so long as one of them is not the governor. The law does not apply to private entities. A common unsuccessful defense to the Sunshine Law is the right to privacy, although the right of access in Florida will overcome this defense. It is still useful to mention this defense in an essay. The three basic requirements of Sunshine Law are meetings of public boards or commissions must be open to the public, reasonable notice of such meetings must be given, and the minutes of the meetings must be taken. Homestead exemption. There are two separate homestead protections in Florida: residence protection and tax deduction. The most frequently tested exemption is Article 10, Section 4, which protects against the forced sale of a person's primary residence from judgment creditors, except for property taxes and obligations for the purchase, improvement, or repair of the house, such as construction liens, mechanics liens, mortgages, and homeowners association fees. This exception applies to residents of up to half an acre inside a municipality and up to 160 contiguous acres outside a municipality. It also protects personal property up to $1,000. Furthermore, the homestead shall not be subject to devise if the owner is survived by a spouse or minor child, except the homestead may be devised to the owner's spouse if there is no minor child. The owner of a homestead real estate, joined by the spouse if married, may alienate the homestead by mortgage, sale, or gift, and if married, may by deed transfer the title to an estate by the entirety with the spouse. The homestead is also portable and applies to proceeds of the sale of a homestead, so long as the proceeds will be able to purchase a new homestead. The homestead tax deduction includes a general $25,000 deduction that applies to all taxing authorities and a second $25,000 deduction that excludes school board taxes and applies to properties with assessed values greater than $50,000. Therefore, most homeowners in Florida can take a $50,000 deduction from the value of their homestead for tax purposes. Essentially, the homestead exemption protects a Floridian's primary residence from forced sale by judgment creditors, except Uncle Sam, and debts incurred as a result of financing or improving the home. It is limited to half an acre inside a municipality or 160 contiguous acres outside a municipality. Look for a street that divides a property and would end the homestead at the dividing line. A person can only claim one homestead, and so can their spouse and children. Homestead exemption is also a $50,000 tax deduction from the value of the home. Enacting law in Florida. A proposed bill must have a clear title, a single subject, and enactment clause, be related to the health, welfare of the people of Florida, and not be vague or overbroad. In order to become a law, there must be bicameralism, improved in both the House of Representatives and the Senate, and be read 3 times, and there must be presentment to the governor for signature. There's no pocket veto in Florida, so an unsigned bill that has been passed in both houses still becomes law. Be careful, as these procedures are necessary for passing laws in Florida, but not all rules and regulations, such as municipal ordinances, need to comply with the strict formalities of enacting a law, although they can never be vague or overbroad and must always survive constitutional muster. Types of laws in Florida. General laws are laws that cover everyone in the state even-handedly and only require passage of the Florida legislature. A special law is one that applies to only a certain person or groups of persons or a certain geographic area such as a city. Special laws require either notice before the passing or a referendum after the passing, or the law will have no effect. General laws of local application are laws that are general laws that apply uniformly to an area, such as one that has a minimum or maximum population requirement. A good argument to make in an essay is that a general law of local application is targeting a specific county and thus is attempting to circumvent voting requirements of a special law. Home rule power. In Florida, municipalities are vested with home rule powers such that they can regulate and exercise traditional municipal powers. These powers include the ability to pass municipal ordinances which affect people in the municipality. Such ordinances may not conflict with the laws of the Florida legislature or impinge upon the Florida Constitution. Of course, the same applies for the U.S. Constitution and federal laws. The Supremacy Clause restricts overreaching ordinances. Types of laws in Florida. There are chartered counties and non-chartered counties in Florida. Chartered counties have home rule power, whereas non-chartered counties are subject to the general laws of the state. Special legislative session. The governor has the authority under the Florida Constitution to call a special legislative session. Special legislative sessions must be limited in scope, and the absence of the requisite vote of the members of the House and Senate, 2/3 vote. No new matters may be addressed during a special session, other than for those for which the special session was called. While regular legislative sessions last for 60 consecutive days, special sessions can last up to 20 days and are convened at the request of the governor or joint proclamation by the Speaker of the House and the Senate President. Separation of powers. Just as there must be a separation of powers at the federal level, there cannot be encroachment or entanglement at the state or local level. Certain powers are vested to respective branches. Be especially on the lookout for law or ordinance that unconstitutionally grant sentencing power to a legislative or executive branch. Constitutional officers. Constitutional officers in Florida include the governor, the lieutenant governor, the CFO, the commissioner of agriculture, state attorneys, public defenders, sheriffs, tax collectors, property appraisers, supervisor of elections, clerks of the circuit court, county commissioners, district school board members, and superintendents of schools. These officers have vested duties and must complete relevant ethics courses. Pfluger Doctrine. The Florida Constitution provides that the right to access to courts will not be infringed upon and that justice will be administered without sale, denial, or delay. When the legislator significantly burdens this right in a manner that amounts to abolishing a cause of action, a reasonable alternative must be provided unless the legislator can make the difficult showing that a public necessity exists and that no alternative can reasonably be established. Kruger versus White test. Amendments to the Florida Constitution. Proposed amendments to the Florida Constitution may be made by a joint resolution of the Florida legislature, a citizen's initiative, a proposal from the Constitution Revision Commission, or a proposal from the Taxation and Budget Reform Commission. A proposed amendment requires at least 60% approval from voters to pass. Defamation. Defamation can be slander, spoken or libel, written. Defamation of a public figure requires actual malice. Defamation is not protected by the First Amendment. Express right to privacy. The Florida Constitution states every natural person has the right to be let alone and free from governmental intrusion in their private life, except as otherwise provided herein. This section shall not be construed to limit the public's right of access to public records and means as provided by law. It can thus be interpreted that Florida's protection of privacy is even greater than that afforded by the U.S. Constitution. It is also important to note and discuss on an essay that the right to privacy will not overcome a sunshine law argument. Right to work. In Florida, the right to work is a enumerated right in the Florida Constitution. These rights are looked upon as fundamental rights. In Florida, one may not be granted or denied work based on their membership or non-membership to a union. Municipal bond. In Florida, there are two types of bonds that may be issued in order to finance government projects. General obligation bonds are bonds that repayment is guaranteed by the full faith of the government. In order to pass a general obligation bond, there must be a referendum by the people on whether it may be issued. Types of GO bonds include parks and schools. Revenue bonds are bonds that are paid back from the revenue that the project generates. Types of rev bonds include toll bridges and airports. Revenue bonds may be subject to feasibility studies. Municipalities may issue a bond without a vote if it matures within 1 year. Excessive bail. The purpose of a bail determination in a criminal proceeding is to ensure the appearance of the criminal defendant at subsequent proceedings and to protect the community against unreasonable danger from the criminal defendant. Under the 8th Amendment of the U.S. Constitution, and similarly adopted by the Florida Constitution, bail is excessive when it is set a figure higher than an amount reasonably calculated to ensure the asserted governmental interest. Taxation considerations. Normally, all municipality property is exempt from ad valorem taxes, property taxes. However, when deciding if the municipality property is exempt from ad valorem taxes, you must look to the governmental purpose versus the commercial purpose test. If the land is being used for a private purpose, it is not exempt from ad valorem taxes. On the other hand, if the property is being used for the government purpose, it will be exempted from paying these taxes. It is important to note that ad valorem taxes are levied by counties and municipalities, not the state. Rights of convicted felons. A person who has been convicted of a felony is not eligible to vote in Florida unless they have had their right to vote restored. Once their right to vote has been restored, they can register to vote. The Voting Restoration Amendment, known as Amendment 4, restores voting rights to felony offenders, except those convicted of murder or a felony sexual offense, upon completion of all terms of sentencing, including parole or probation. Furthermore, convicted felons who have not had their rights restored via clemency are prohibited from possessing firearms, serving on juries, holding public offices, holding certain professional licenses, and entering certain foreign nations. Pocket vetoes. Unlike the president, the governor cannot execute a pocket veto, which means if the governor fails to sign a bill that has passed both chambers, it still becomes a law. During a legislative session, the governor must sign or veto legislation within 7 days of transmittal, or it becomes law without his or her signature. Post-session, if the legislative session adjourns sine die, whatever, with no appointment date for resumption, or for more than 30 days during the original 7-day deadline, then the governor must sign or veto legislation within 15 days of transmittal, or it becomes law without being signed. Advisory opinions. Unlike the Supreme Court, the Florida Supreme Court can issue advisory opinions. Under the Florida Constitution, the governor may request a written opinion from the Florida Supreme Court on certain legal issues, and the justices may render their written opinion not earlier than 10 days from the filing and docketing the request, unless in their judgment the delay would cause public injury. Rules of judicial procedure. Normally, the legislator passes a bill by a majority of each house and then presents such a bill to the governor to either veto or to sign. Under the Florida Constitution, however, the Florida Supreme Court has the exclusive authority to create rules of procedure for the Florida courts. The legislator may reject such rules created by the Florida Supreme Court by a 2/3 vote, but the legislator may not amend or modify such rules. The Florida legislature has no power to create rules of court procedure, as this power is exclusively vested in the Florida Supreme Court, according to the Florida Constitution. Prohibited subject matters. Special laws, as well as general laws of local application, cannot cover certain subject matter that the Florida Constitution expressly prohibits. Such prohibited subject matter includes taxation, elections, petit juries, conditioned precedent to bring civil or criminal claims, venue rules, and rules of evidence. These subject matters are preempted by Florida state law. Original jurisdiction of the Florida Supreme Court. The Florida Constitution gives the Florida Supreme Court the discretionary jurisdiction to hear appeals from the District Court of Appeals for a variety of reasons, including if two DCA opinions conflict, if they are certified to the Florida Supreme Court as of great importance, or if they affirm the validity of a Florida statute or constitutional provision. The Florida Supreme Court has mandatory jurisdiction of appeals arising out of the District Court of Appeals relating to bond validation proceedings, imposition of death penalty, and the invalidation of a statute or constitutional provision. The Florida legislature may not extend or enlarge the discretionary jurisdiction of the Florida Supreme Court as constitutionally mandated. In contrast, under the Florida Constitution, Congress has the power to enlarge or reduce the appellate jurisdiction of the U.S. Supreme Court, provided that it does so without excluding appellate jurisdiction of entire subject of review. Finally, I've ranked the most commonly tested issues on a con crim law essay. Fourth Amendment right against unreasonable searches and seizures. The Fourth Amendment of the U.S. Constitution, which is mirrored by the Florida Constitution, protects against unreasonable searches and seizures. Private individuals have a reasonable expectation of privacy in their persons and effects. A search occurs when a government or law enforcement agent conducts a search of property, information, or conversations, and there must be probable cause supported by a warrant, or a circumstance excusing a warrant. Whether the police have a legal basis for stopping and arresting a person depends on the totality of circumstances surrounding each stop or arrest. Fifth Amendment Miranda rights. The Fifth Amendment right to counsel attaches when a person is placed in custody. Custody is generally defined as any situation where a reasonable suspect would not feel free to leave, or where they are deprived of their freedom of action in any significant way. A person is not in custody during a routine traffic stop, but once they have been arrested, they're in custody. Under Miranda, police must inform a person in custody of certain rights before conducting interrogation, which refers not only to express questioning, but also to any words or actions on the part of police, other than those normally attendant to arrest in custody, that the police should know are reasonably likely to elicit an incriminating response from the suspect. Specifically, the Miranda warnings include the right to remain silent, that anything the suspect says or does may be used against them in the court of law, that they have the right to an attorney, and that if they cannot afford an attorney, one will be provided for them. It is important to note the lack of languages are not required. See what I did there? If a suspect invokes their Miranda rights, police can continue interrogation for a reasonable time, 14 days. Any can not continue interrogation for a reasonable time, 14 days. Any statements made voluntarily or unsolicited will be admissible. A violation of Miranda rights results in the inadmissibility of evidence, not the automatic dismissal of the charges. Sixth Amendment right to counsel and speedy trial. While the Fifth Amendment of the Constitution guarantees the right to counsel before adversarial proceedings have begun, the Sixth Amendment right to counsel attaches after charges have been filed. Unlike the Fifth, the Sixth Amendment right to counsel is offense-specific. The Sixth Amendment also preserves the right to speedy trial, the right to an impartial jury, the right to be tried in the jurisdiction where the alleged crime took place, vicinage, and the right to be informed of the charges, the right to confront the individuals making the accusation, the right to compel defense witnesses to testify, the right to assistance of counsel, which includes the right of counsel of defendant's choice, the right of appointed counsel, the right of conflict-free counsel, the right to effective assistance of counsel, and the right to represent oneself without counsel. The exclusionary rule. The exclusionary rule provides that evidence that the government obtained in violation of an individual's constitutional rights is barred from admission at their trial. Under Rule 3.190 of Florida's Rules of Criminal Procedure, a defendant aggrieved by an unlawful search and seizure may move to suppress anything so obtained for use as evidence because the property was illegally seized without a warrant, the warrant is insufficient on its face, the property seized is not the property described in the warrant, there was no probable cause for believing the existence of a grounds on which the warrant was issued, or the warrant was illegally executed. A motion to suppress is typically filed before the commencement of trial before a jury. Fruit of the poisonous tree doctrine. Under this rule, any evidence that is a direct result of illegal conduct on the part of an official is inadmissible in a criminal trial against the victim of the conduct. The Supreme Court has ruled that everything that the officer discovers as a result of an illegal arrest are fruit of the poisonous tree, not just a statement itself, but also the witness information gleaned from it and any other evidence subsequent that the witness led them to. Even a confession that comes after Miranda warnings may be inadmissible if it's the product of an illegal arrest and police misconduct, and the confession and illegal arrest are closely related. Exceptions to the fruit of the poisonous tree doctrine include the inevitable discovery doctrine. The evidence would have been discovered by other lawful means. The attenuation doctrine, there was no legitimate reason for the stop, but then the officer discovers an active warrant. And the intervening event doctrine, a voluntary admission is given after an impermissible search and is a separate basis for obtaining evidence. Warrant requirements. In Florida, a search or arrest warrant must be issued by a neutral magistrate and contain a signature by an impartial judge. The name of the person being searched, a description of the items and premises searched, the person or items that are to be seized, any communication to be interpreted, and probable cause justifying the warrant. Exception to the warrant requirement. There are exceptions to needing a warrant to conduct a search, and the mnemonic spaces can be used to remember them. The exceptions include search into arrest, plain view doctrine, automobile exception, consent, exigent circumstances like hot pursuit, and the stop and frisk doctrine. Search into arrest. When a police officer lawfully arrests the occupant of a vehicle, he may, right then and there, search the passenger compartment of the vehicle, as well as any containers found in the passenger compartment. The reasons why she may do so are to remove any weapons contained in the car that the arrested person might try to obtain in order to hurt the officer with, and to prevent the arrested person from concealing or destroying evidence such as drugs contained in the car. Plain view doctrine. Florida police officers do not need a search warrant if they can see evidence of illegal activity as in plain view. Immediately apparent for purposes of plain view doctrine means at the time the police view the object to be seized, they must have probable cause to believe that the object is contraband or evidence of a crime. Automobile exception. Under the automobile exception, the officer can perform a limited pat search of the driver and passengers for weapons if the police have reasonable suspicion to believe someone in the car is armed and dangerous. The scope of the search is not limited to the driver and passengers. Consent. If a person consents to a search, no warrant is required. A roommate can consent to a search of a common areas, but not to the roommate's room. If one roommate denies consent to a common area, there can be no search without a warrant. Exigent circumstances. The Supreme Court has identified several exigent circumstances that may justify a warrantless entry of a home, which include preventing violence and restoring order, rendering emergency assistance to an injured occupant, or to protect an occupant from imminent injury, preventing the destruction of evidence or some other consequence improperly frustrating legitimate law enforcement efforts, or hot pursuit of a fleeing felony suspect. And then stop and frisk. Florida stop and frisk law authorizes officers to temporarily detain an individual when the circumstances reasonably indicate the person committed is committing or is about to commit a criminal offense. Terry stop. For a Terry stop to be legal in Florida, officers must have a reasonable suspicion based on specific and articulable facts that a crime has been, is being, or is about to be committed. There's a lower standard than probable cause for arrest. Factors creating reasonable suspicion may include a mass description of a suspect, suspicious behavior, evasiveness, unprovoked flight. However, factors like location in a high crime area alone are not enough. Police must point to specific facts about the particular person stopped. Reasonable expectation of privacy. There's a reasonable expectation of privacy for items in a trash can inside of a home that are not placed outside on the sidewalk, for example. Stand your ground laws. In Florida, a person is justified in using or threatening to use force, except deadly force, against another when and to the extent that the person reasonably believes that such conduct is necessary to defend himself or herself or another against the other's imminent use of unlawful force. Impermissibly suggestive lineups. Whether it is a photographic or live lineup, prior to beginning the lineup, the eyewitness must be told that the perpetrator might or might not be in the lineup. The lineup administrator does not know the suspect's identity, only stated during a live lineup. The eyewitness should not feel compelled to make an identification. Make an identification. It is important to exclude innocent persons as it is as important to exclude innocent persons as it is to identify the perpetrator, and the investigation will continue with or without an identification. A lineup or photo array is impermissibly suggested if the accused, when compared with the others, is conspicuously singled out in some manner from others, either from appearance or statements by an officer. It is also conceivable, though rare, that they will test certain Florida crimes on essay and have identified some of the most likely crimes to be tested. I have relied on information provided from Florida criminal defense attorney Richard Hornsby. And just because this is rare to be tested, I'm not going to read through these all, but so you know, some of these crimes include robbery, conspiracy, burglary, murder, and murder could be in the first degree, second degree, third degree. Defenses to murder include excusable homicide, justifiable homicide, and self-defense. And then Florida stand your ground law, a person who is attacked, who has no duty to retreat, and the right to stand your ground and meet force with force, including deadly force, if it is reasonably believed necessary to prevent death or great bodily harm, or to prevent the commission of a forcible felony. So I think I actually changed that. In Florida, a person is justified in using or threatening to use force, except deadly force, unless it is reasonably necessary against another when and to the extent. Okay, so those are the crimes. Then I also, sorry, manslaughter, manslaughter by act, manslaughter by procurement, manslaughter by culpable negligence, and then the theft and fraud crimes, bribery involving public official, dealing in stolen property, defrauding an innkeeper, exploitation of elderly persons or disabled adult, extortion, forgery, failure to redeliver hired vehicle, fraudulent use of credit cards, fraudulent use of personal identification, grand theft, issuing worthless checks, obtaining property by worthless checks, petite theft, retail theft, scheme to defraud, theft or lost property or abandoned property, theft of state funds, and uttering forged instruments. You see, Florida doesn't have larceny. It has a whole litany of theft crimes. And then arson. Arson is when a person willfully and unlawfully damages a dwelling or structure by fire or explosion. Attempt, solicitation. Right, attempt and solicitation will merge with the completed crime, whereas conspiracy will not. And then vehicular homicide. I know this was an extremely long letter, but I want to be sure that you had all the information necessary to crush a Florida bar con law essay. I hope you review these points carefully. I'm here to help if you have any questions. Andrew. Real property. Dear Stick Boy, I'm just writing to see how you're doing with your studies. Andrew. Dear Stick Boy, how's it going? The test is just a month away. I haven't heard from you since I sent my last letter. I just want to check in and make sure you've been keeping up with your studies. Your friend, Andrew. Dear Stick Boy, I'm getting a bit worried about you. I trust that you've been working hard. In my Florida MBE class, I had them work on a group assignment that I thought would be valuable to you and any student taking the bar. I identified 100 difficult vocabulary terms related to property and assigned a few terms to each student to identify. I am sending you this list and I hope it'll help you. Again, I'm not going to go over this entire list. I'm just going to identify the terms. Easement of pertinent, easement by prescription, easement in gross, easement by necessity, adverse possession, tenancy by the entirety, straw man, joint tenancy with right of survivorship, tenancy in common, inquiry notice, actual notice, constructive notice, partition, deed by estoppel, equitable mortgage, junior mortgage, mortgagor, mortgagee, common interest development, holdover tenant, sizing, quiet enjoyment, marketable title, deed in lieu of foreclosure, merger, condemnation, reverse condemnation, eminent domain, statute of frauds, attornment, privity, primarily liable, surety, secondary liable, purchase money mortgage, prepayment fees expressly assumed, subject to title theory, lien theory, pure notice, race notice, equitable servitude, real covenant, accession, non-conforming use, variance, amortization, equitable conversion, rule against perpetuities, right against first refusal, encumbrance, foreclosure, general warranty deed, including right to convey, size and no encumbrances, quiet enjoyment, general warranties and further assurances, quick claim deed, special warranty deed, fee simple absolute, fee simple determinable, fee simple subject to conditions subsequent, fee simple subject to executory interest, springing executory interest, shifting executory interest, due on sale clause, acceleration clause, fixtures, trade fixtures, affirmative waste, permissive waste, ameliorative waste, license, profit or prendre, exaction, cumulative zoning ordinance, non-cumulative zoning ordinance, tax deed, bona fide purchaser, shelter rule, color of title, action to quiet title, remainder man, life tenant, habitability, tenancy at sufferance, periodic tenancy, tenancy for years, tenancy at will, redemption, novation, horizontal privity, vertical privity, right to list, right to sell, escrow, lien, lease pendants, due diligence, as is clause, duty to disclose, appraisal, hardship variance, wild deed, caveat emptor, littoral rights, riparian rights, life estate per ultra v, Fair Housing Act, exoneration, lapse, negative easement, serving estate, dominant estate, per stirpes, judgment creditor, tacking, and retaliatory eviction. This is a list that my class one day I assigned them each a few words and they all defined for me. And I included this in the essay guidebook because for real property, vocabulary can be one of the most difficult things. So something to go over for sure. I hope you receive this letter and that all is well. Sincerely, Andrew. Dear Stick Boy, I'm writing one last time because I don't want to give up on you. If you decide to postpone the exam, please know that I support your decision and we're ready to help you prepare. I hope all is well with you and yours. Peace be the journey, Andrew. Andrew, I'm so sorry I've not responded to your letters. I've had a lot going on. To make a long story short, there's a stick baby on the way. I am sitting for the exam in 2 weeks and need your help on property, family law, and ethics. That property worksheet your class created is so helpful, and I've been studying it diligently. If there's not too much to ask, I was hoping you could send me 3 letters as quickly as possible regarding the remaining essay subjects. I'm sorry for such an inconvenience, but I'm committed to passing this test more than ever since receiving the news of the baby. Thank you for everything, and I hope you're doing well. And your pups, Rosie and Biscuit, also. The Stick Father. Sticky, I'm so happy to hear the news. Fatherhood is the greatest gift a man or stick could ever receive, and you are blessed. I'm more than happy to oblige to your request, and this will be my first letter detailing how to address real property essays in the Florida bar exam. I find property to be the toughest subject overall because, like con law, there are many different avenues the bar examiners can require you to walk them down. I've tried to craft a few different blueprints navigating real property essays. It's important to remember that some essays will require multiple blueprints, and most essays test overlapping subjects such as contracts and torts or con law, family law, and ethics, for example. The story of Stickacre. And again, some of these definitions you can refer to above. Stickacre represents a hypothetical piece of property where we can counter on essay. Stickacre represents a hypothetical piece of property we can encounter on essay that multiple parties have interest in. We should first acknowledge that Florida is a lien theory state, which means that encumbrances on properties will not sever joint tenancies with rights of survivorship, and that the death of a party will terminate any mortgage or lien that party took out on the property personally. Under lien theory, the homeowner, who is also the buyer, holds the deed to the real estate property for the life of the mortgage instead of the lender, who would typically under title theory. Another commonly tested distinction is that Florida is a pure notice jurisdiction, which protects bona fide purchasers. A BFP takes for value in good faith without notice. Different types of notice include actual notice, literal notice, and constructive notice, which can be either inquiry or regional inspection would have put someone on notice, or record. There's a recording in the county records. A Stickacre may be conveyed as a fee simple absolute or the feasible fee, such as a fee simple determinable, a fee simple subject to a condition subsequent, or a fee simple subject to executory interest. A life estate is a conveyance that allows someone to make use of a property during a measured lifetime before it vests with the remainder man. Life estate tenants cannot commit waste and must pay the taxes and interest on the mortgage unless the property is vacant and unproductive. A remainder man pays the principal of the mortgage. Typically, Florida real property essays do not require analysis of these type of possessory estates, but rather of different types of tenancies. Tenancies are presumed to be tenancies in common, where the tenant's stake of the property is descended by the estates, and test is here by will. In a joint tenancy with right of survivorship, Tenants survive each other. A JTROS must contain the four unities of time, title, interest, and possession. A tenancy by entirety is a JTROS plus marriage, and Florida has eliminated the need for a straw man to convert a TIC into a TBE. If joint tenants get into a dispute, they can seek a partition of the property, either a physical partition or judicial sale to split proceeds. However, remainder men have no right to seek a partition. A tax deed is a way to obtain ownership of property by paying delinquent taxes. It is very likely that there will be a mortgage on Stickacre. A mortgage is a loan secured by property. In the event of a default, the mortgagee, the lender, can institute a foreclosure action which can result in the forced sale of the property. A foreclosure sale will extinguish junior mortgages on the property. If the sale of the home cannot pay off the senior mortgage and/or junior mortgages, they can seek deficiency judgments against the mortgagor, the borrower, to recover. Senior mortgages are the first mortgagees to record, with the exception of purchase money mortgages. A PMM is when the money borrowed is used to buy the property and is the highest priority mortgage. A mortgage can be expressly assumed, so the new mortgagor is personally liable. A mortgage can be taken subject to, which means the new mortgagor is only secondarily liable. When there's a foreclosure, there's an equitable right of redemption, which allows the mortgagor to buy the property before the sale, and a statutory right of redemption, which allows the mortgagor to pay off any outstanding balances, fees, and taxes to essentially buy back property for a limited time after the sale. There are certain clauses that are enforceable if agreed upon, such as a due on sale clause, which requires payment of the entire balance of the mortgage upon the sale of the property, an acceleration clause, which permits the lender to require the entire balance to be paid upon delinquent payments, and a no early prepayment clause, which prevents the mortgagor from paying off the mortgage earlier than agreed upon. An equitable mortgage arises when there's a loan secured by property, but is not recorded officially as a mortgage. A deed in lieu of foreclosure is an agreement between the lender and borrower to surrender the deed to the property instead of going through a foreclosure sale. A deed in lieu of foreclosure will not extinguish junior mortgages. Stickacre could have some issues. There could be an easement on the property, and it could be an express easement, an implied easement, an easement in gross, an easement of pertinent, an easement by prescription, an easement by necessity, an affirmative easement, and/or a negative easement. The time period for acquiring a prescriptive easement in Florida is 20 years. A prescriptive easement does not require exclusivity, but otherwise has the same elements as adverse possession: hostile, open, continuous, adverse, and notorious. Florida does not recognize a negative easement for lighter air under Fontainebleau versus Eden Rock, but most jurisdictions in Florida have riparian rights or water rights. A plausible argument against the existence of an easement is that only a license was created. A license is a revocable right to use property, whereas an easement runs with the land. Easements can be extinguished by express release by the easement holder, subject to statute of frauds, abandonment, merger, agreed upon termination, condemnation, destruction of the surveyed estate, or end of necessity. The proper remedy for overuse or misuse of an easement is not to terminate the easement, but rather injunctive relief in the form of a surcharge requiring the overuse/misuse to stop and potentially awarding monetary damages. Generally, is the duty of the dominant estate, not the serving estate, to maintain and repair the easement. Stickacre could also be subject to restrictive covenants. A real covenant is a land restriction remedied by legal relief and money, and an equitable servitude is a land restriction remedied by equitable relief, injunction. In order for either an equitable servitude or real covenant to run with the land, there must be notice, intent, and it must touch and concern the land. Real covenants must be in writing and require privity. Stickacre could be acquired via adverse possession. In Florida, the time necessary to acquire title by adverse possession is 7 years. It is possible for consecutive squatters to combine their time to reach this necessary time limit, which is known as tacking. There are 2 ways to acquire land by adverse possession in Florida: with or without color of title. Color of title is the appearance of title, usually in the form of a defective instrument such as a deed purporting title. Under color of title, the claimant needs to have placed an enclosure such as a fence around the property or improved or cultivated the property in some way. Without color of title, the claimant needs to have paid outstanding taxes on the property and continue to pay property taxes. Remember that Stickacre could be a homestead property and therefore be protected from the forced sale by most judgment creditors. Buzzwords to look out for are acreage numbers to signify a homestead, a fence to signify adverse possession, and a pathway to signify an easement. While there are many issues related to the property of Stickacre itself, there are equally as many potential issues between the contracting parties. One potential issue is when 2 or more parties have conflicting claims of ownership on a property and must seek an action to quiet title. One of the least commonly tested aspects of property law is the rule against perpetuities, RAP, which states that no property interest in land is valid unless it must vest at all within 21 years of the death of a life in being at the time the interest was created, or actually vest within 1,000 years in Florida. In summary, if you see a property like Stickacre, analyze what type of property it is, who has interest in the property, and identify the different encumbrances on the property. Above all else, make sure to explain to the reader that Florida is a lien theory state and a pure notice jurisdiction. Larry versus Tommy, leasehold issues. Another rather heavily tested area of property law is the realm of landlord and tenant. Landlords have the main duties to deliver legal right and actual possession of the property and maintain the duties of habitability and quiet enjoyment. The warranty of habitability is implied in all residential leases and requires a landlord to ensure the premise remains habitable, or in other words, livable. For instance, operating AC, running water, heat in the winter, no exposure to outside elements. Essentially, a landlord has a duty to reasonably inspect the premises for habitability and maintain the premises habitable by complying with housing and health codes, and when there is any duty to maintain roofs, screens, doors, floors, steps, exterior walls, foundations, and all other structure components in good repair. In regards to repair, a landlord is presumed to be responsible for repairs in residential leases, so long as the tenant notifies the repairs and gives the landlord reasonable time to make the repairs. In a commercial lease, the landlord can place the duty of repairs on tenants. Under the warranty of quiet enjoyment, the tenant can withhold rent when the landlord makes the premises wholly or substantially unsuitable for its intended purpose, and the tenant is constructively evicted. If the landlord renders the property substantially unsuitable in whole or in part, the tenant may terminate the lease and seek damages under the theory of constructive eviction. When the landlord's actions cause the injury, the resulting conditions must be so bad that render the place inhabitable, and the tenant must vacate the property. The landlord has 15 days to give back a security deposit unless they're making a claim on it, which must be made within 30 days. The tenant can object to the claim, or otherwise the landlord takes the appropriate amount and returns the rest in 15 days. The tenant has a duty to pay rent, avoid waste, and if agreed upon, may have a contractual duty to repair in commercial leaseholds. The duty to pay rent is excusable only when the premises are destroyed and the tenant did not cause the damage. The landlord completely or partially evicted the tenant, and the landlord breaches his obligations or duties. Tenants also have the duty to avoid waste. This is a background rule and does not need to be expressed in the lease contract. The tenant has the duty not to commit affirmative voluntary waste or permissive neglectful waste. Ameliorative waste, which actually improves the value of the property, is still an actual breach of duty. There are 4 types of tenancies, and when we use the mnemonic, your period will suffer to remember. Just a side note that this is mnemonic, not an acronym. Examples of acronyms are USA, FBI, and IRS. Just a side note that both you and I, Stick Boys, should consider ourselves lucky and fortunate that this particular mnemonic does not resonate deeply with us. Tenancy for years. A tenancy for years is an estate lease agreement that lasts a specific amount of time with opportunities for renewal at the end of each lease. These fixed-term tenancy contracts have clearly defined beginning and end dates and a specified rent payment that both the lessee and the lessor must agree to. If the lease is for less than a year, no writing is required. A tenancy for years terminates automatically at the end. Florida allows a notice to be required, but no more than 60 days, and both parties must agree. Periodic tenancy. A periodic tenancy is a leasehold agreement with no specific end date. It is presumed to repeat for successive periods until either party gives notice of intent to end the agreement. In Florida, there are specific notice requirements for terminating a periodic lease. A year-to-year lease requires 60 days notice for residential periodic tenancies and 90-day notice for non-residential periodic tenancies. A quarter-to-quarter lease requires 30-day notice for residential and 45-day notice for non-residential. A month-to-month lease requires 15 days for residential and non-residential leases. A week-to-week requires 7 days for residential and non-residential leases. Types of non-residential leases include commercial and industrial leases. Tenancy at will. A tenancy at will endures indefinitely and can be terminated by either party at any time. Unless the parties agree otherwise, no notice is required for termination. Tenancy at sufferance. A tenancy at sufferance occurs when the tenant continues in possession after the lease term ends, a holdover tenant situation. The landlord may evict the tenant or bind the tenant to a new periodic period. In Florida, the landlord cannot use force, self-help, to regain possession of the premises. Instead, the landlord must serve the tenant with notice of a lawsuit and get a court judgment of possession. Landlords may collect double rent for the time during the holdover if residential or non-residential tenants refuse to surrender possession of the premises. In summary, you may very well get an essay where Larry the landlord is fighting with Tommy the tenant. Remember that Larry has the duties of habitability and quiet enjoyment, and Tommy needs to pay rent and not commit waste. The contract and the deed, a love story. Okay. All land sales must be in writing in order to conform with the statute of frauds. Partial performance will exempt the real estate contract from the statute of frauds if there is payment, improvement, and/or possession. The contract must include a sufficient description of the real property to be sold, the parcel number or the meets and bounds measurement, identification of the parties, a contemplated closing date, purchase price of the amount of the property, closing costs, and the property taxes. Other factors mentioned in a land sale contract can include the amount of any earnest money deposit to be paid by the buyer, the manner of payment of the sale price by the buyer, including when it will be paid, whether transaction will be cash closing or involve financing, financing terms, including any security interest to be retained by the seller, dates when any deferred payments will become due, how interest will be calculated in the event of deferred payments, whether the buyer will assume an existing mortgage, whether the seller or buyer will pay to discharge substantial liens on the property, and any other acts to be performed by the buyer for the seller or vice versa. The appropriate remedy for breach of contract claims concerning real property is specific performance. All sellers of residential real property have a duty to disclose known defects and latent defects that are not apparent, and the seller is unlikely to discover it by the ordinary inspection if the defects are serious and would probably cause the buyer to reconsider the purchase if it were known. The duty to disclose latent defects was established by the landmark Johnson v. Davis decision in Florida. Under Johnson v. Davis, the conveyor has a duty to disclose defects, and therefore caveat emptor, buyer beware, does not apply. An as-is clause is a general disclaimer. Property is sold as is or without or with all faults and does not absolve a seller of liability in residential property, although it may in commercial property. A specific disclaimer, like seller makes no warranties as to the condition of the roof, will likely be effective, however, even in residential property sales. A seller of real property can also be liable for active concealment, misrepresentation, or puffery. Concealment occurs if the seller took steps to hide a defect in the property. A misrepresentation occurs when the seller knew the statement was false, or should have known it was false, or such a statement materially affects the value of the property. The three types of misrepresentation are fraudulent, negligent, and innocent misrepresentation. Fraudulent misrepresentation is deliberate withholding of important information. Negligent misrepresentation stems from inaccurate statements that lack reasonable justification, and innocent misrepresentation occurs when an agent considers an accurate piece of information as true. Puffing or puffery is defined as the exaggeration of material facts. An example of puffing in real estate is when an agent makes an outrageous remark about the quality of a listing, but it turns out to be exaggerated claims. All conveyances of land have an implied warranty of delivering marketable title, which means a title free from any claims or disputes about the ownership or from any threat of litigation. Therefore, any undisclosed or unagreed upon encumbrances such as a mortgage, lien, judgment, unpaid taxes, or easement on the property would render title unmarketable. Similarly, any property that is acquired by adverse possession as a defeasible fee is subject to unusual zoning restrictions, has a lease pending, or threat of litigation is considered unmarketable. Parties can contract to less than marketable title. Florida recognizes the doctrine of equitable conversion, which means that during the period of escrow, in between the signing of the contract and the closing, the risk of loss shifts to the buyer as the buyer becomes the equitable owner, while the seller retains legal title until the closing. Under the theory of equitable conversion, if either party dies during the escrow period, their estate will still be required to follow through with the closing. It is important to note that the land sale contract will merge into the deed, and once the deed is recorded, the buyer and seller will forfeit any lingering claims related to the contract. If there are any conflicting terms between the contract and the deed, then the terms of the deed will prevail. The deed is a legal instrument that grants title to the owner, and its proper recording should put others on notice of the interest. Whereas title is a legal ownership, Whereas a title is legal ownership in an abstract sense, the deed is a statement of legal ownership in written form. It is possible to have title without deed, for instance, if title is acquired via adverse possession. Deed formalities require that deeds must be signed, written, attested by 2 witnesses, and contain an accurate description of the land. There are 3 types of deeds: a quitclaim deed, where the guarantor makes no promise about title; a special warranty deed, where the guarantor warrants that no undisclosed title defects be attached during his or her period of ownership; and a general warranty deed, where the guarantor makes certain covenants regarding title to property. A general warranty deed is a default deed in Florida, and it warrants a clear chain of title. The general warranty deed includes the 3 present covenants of seisin, the right to convey, and the right against encumbrances. Seisin means that the grantor owns and possesses the property. Right to convey means the grantor has authority to convey title. Covenant against encumbrances means there are no undisclosed encumbrances over the property. The future covenants, which can be brought after the deed has been recorded, include quiet enjoyment, general warranties, and further assurances. Quiet enjoyment means there's no third party with superior claim to the property. General warranties mean that if a third party establishes they have superior claim, the grantor will compensate the grantee for the loss. Further assurances means that the grantor promises to take any acts that are reasonably necessary to pass title to the grantee. If there are conflicting claims to a property, as mentioned above, the parties may initiate an action to quiet title to determine who has superior title. In summary, try to recognize how title to property was acquired and whether there were any related breach of contract claims or breach of warranty claims. It is very likely that a property essay will be mixed with a contracts essay because of a love story between contracts and deeds. Speaking of love stories, I'm so happy to hear about your new baby. Please tell me more details. Sincerely, Andrew. Family law. Dear Stick Boy, in honor of your growing family, I'm excited to share this letter to concisely illustrate how to approach a family law essay on the Florida bar exam. Fortunately, over the years, I've had multiple instructors who are also practicing family law attorneys, and together we developed the mnemonic JVPeace with a side of mustard. This stands for jurisdiction, venue, parenting plan, equitable distribution, alimony, child support, esquire fees, divorce/dissolution of marriage, and modification. Jurisdiction. A court may have personal jurisdiction over a party to a proceeding related to the dissolution of marriage via domicile, consent, or minimum contacts. To file for divorce in Florida, at least one of the spouses must be residing in Florida for at least 6 months. The UCCJEA applies to children and requires that the child must have been a resident of Florida for 6 months or have been born there in order for the court to have jurisdiction. If the 6-month requirement is not met, jurisdiction is valid in the state the parties reside in before moving to Florida. All divorce proceedings are heard in circuit court. Any court that issues a final divorce settlement maintains continuing jurisdiction over related matters, including petitions for modifications. Venue. Venue is proper in the circuit court of the county where at least one of the spouses resides, where the marriage last existed, or the breach that caused the split occurred. Parenting plan. There's a moving preference amongst Florida courts to use the term time sharing in place of custody in reference to the term used in the parenting plan for dividing up the responsibilities of child rearing. When 2 parties have children in common, the court will determine if the parties cannot agree, legal and physical time sharing, and enter a parenting plan. They'll be determined by considering the best interest of the child. In Florida, there's a constitutionally protected right to raise your children, so it's preferred that parenting plans allow for time spent with both parents. The assumption is a shared or split parenting plan where the parents divide time with the children equally. An ultimate parenting plan divides time sharing responsibilities by a specific area, such as education for the mother and sports for the father. Sole parenting is awarded when one party is a danger to the child. Equitable distribution. Florida follows an equitable distribution framework where all marital assets are divided equally and non-marital assets are returned to the party who owned them when entering the marriage. Marital property includes anything acquired during the marriage, including investments, bank accounts, and vested and non-vested retirement accounts and pensions. Non-marital property includes anything acquired before marriage and not mingled. Exceptions apply, such as non-marital gifts or assets devised to one spouse only or inheritances, such as a non-marital gift or assets divided to one spouse only or inheritances. Typically, any assets brought into the marriage will be distributed back out to the spouse who entered with that asset. Some exceptions apply. For example, if a spouse comes into the marriage with the house and the house was improved during the marriage or used as a marital home, the appreciation and value will likely be distributed equally amongst the parties. Under the Homestead Act, the parties are protected from the spouse selling the home without the other spouse's permission. This right can be waived in a premarital agreement. Alimony. In determining an award of alimony, the court determines the recipient's need and the payer's ability to pay. The court will also consider the age, physical, mental, and emotional health of the parties, their earnings and earning capacity, their education, whether each party has been unemployed, whether either of the parties have been the primary caretaker of the children, the age of the children, and the assets of the parties. The court will also look at marital misconduct such as infidelity, dissipation of marital assets, or abuse. Alimony is allocated based on need and ability to pay. There are 5 types of alimony, including temporary, pendent light during the course of dissolution, rehabilitative, helps one spouse to become independent, bridge the gap, helping one spouse go from one stage of life to the next, and durational, the largest form of alimony, which is largely based on length of marriage. In Florida, a short-term marriage is under 10 years, a mid-term marriage is 10 to 20 years, and a long-term marriage is over 20 years. Florida no longer awards permanent alimony, although anyone who received permanent alimony is considered grandfathered in. Child support. In Florida, child support is determined based on state guidelines. Any deviation from the guidelines by more than 5% will require the judge to show finding to support the deviation. The amount is then allocated between the parents according to their respective need and ability to pay. If a child is spending 20% of nights with the person paying child support, there must be an adjustment. Child support will be determined by the best interest of the child. Esquire fees. Attorney's fees may be awarded in family law matters based on need and ability to pay. Contingency fees are not allowable for domestic disputes. Dissolution. In Florida, divorce will be awarded if the marriage is irretrievably broken. Florida is a no-fault state, and the grounds for divorce are that the marriage is irretrievably broken or one party has been adjudicated mentally incompetent for 3 years or more. If both spouses agree the marriage is irretrievably broken, the court will likely award the divorce without hesitation on this cause. However, if one party believes the divorce to be irretrievably broken and the other party claims otherwise and or requests counseling, the court may, within its broad discretion, either order counseling prior to awarding the divorce or may continue the proceedings to allow time for the parties to cool off and rethink the marriage prior to awarding final judgment. The divorce petition will need to contain the grounds of the divorce. It must establish jurisdiction, the request of the parties, how they would like the judge to rule, and a signature attesting to the truth of the statements within. With a divorce petition, the filing party will have to attach any relevant supporting forms and receive a summons from the court to order service upon the party. The other party will need to be served within 90 days of filing, and the filing party will need to file the certificate of service once completed. The divorce should be filed in county court. A divorce is different from an annulment because an annulment revokes the existence of a marriage, while a divorce ends a marriage. Modification. Upon showing of substantial material change of circumstances, either party may petition to the court for a modification of the final settlement agreement. Florida no longer requires the change to be unanticipated. Parenting plans are modifiable upon the showing of a material change of circumstances. Alimony and child support may be modified based on financial ability, including an increased ability to pay, change in the needs of the parties and the child, guidelines, availability of medical insurance, and retirement of a party for alimony only. Florida no longer recognizes the 50-mile rule, so anytime a spouse moves with children, he, she, non-binary person may be required to petition to the court. Additional family law topics. Prenuptial agreements. Premarital agreements are essentially a contract between the parties regarding how a divorce will be handled, and since they are in consideration of marriage, they must conform with the statute of frauds. The writing will need the essential terms of the parties and a signature of the party to be charged. A premarital agreement may contain any agreement the parties chose, as long as the agreements are legal and were voluntarily entered into. The agreements will be invalid if made under duress or fraud. Further, child support cannot be waived as it belongs to the child, not the parent. Alimony may be waived, but the court will not allow this waiver if it will act to put the spouse in need on state welfare. Postnuptial agreements. A postnuptial agreement should be in writing, although not always technically required in every jurisdiction. It needs to contain legal and voluntary agreements. Postnuptial agreements follow the same guidelines as prenuptials. They are just agreed upon after the marriage. Adoptions. In Florida, the effect of an adoption is that the child has the same legal rights as a biological child. In Florida, single adults or married couples may adopt may jointly adopt. All adoptive parents must be approved through an adoption home study, as well as meet any additional requirements from the private agency. Grandparents, aunts, uncles, and siblings can adopt through kinship adoption, which is a quicker and less expensive process compared to regular adoptions. I'm not sure if you were married or planning to marry the mother of your child, but it's my best advice to seek a prenuptial agreement before marriage. On a related note, good luck with that. I hope this letter has found you well, Andrew. Ethics. Dear Stickboy, as you know, ethics is the most frequently tested subject in the Florida bar exam. As you sit in your chair, waiting for the exam to begin, I want you to recite the following ethics introduction over and over so you can write it instantly when the exam begins. The ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideals and goals of professionalism, the oath of admission to the Florida Bar, the creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. The possible consequences for failure to comply with these ethical duties are suspension, expulsion, and admonishment. I think this is a bulletproof way to address an ethics discussion on a Florida bar essay, and there's nothing better than leading off confidently. I've identified the most likely ethical issues that you can address on your upcoming exam. Duty of confidentiality. The duty of confidentiality runs to both actual and prospective clients if the attorney has met with the client to possibly establish a permanent representation. This duty is broader than the attorney-client privilege, which applies to communications between the attorney for purposes of representation litigation. The duty of confidentiality survives the death of the client and covers all information and representation, however and whenever it was obtained. However, Florida's Rules of Professional Conduct, RPC, do allow for an attorney to break his or her duty of confidentiality in certain situations, including when it's mandatory in order to prevent a crime or bodily harm that the attorney knows the client is going to commit. Furthermore, it's permissive when the client consents, when implied authority was previously given, when an attorney believes it is necessary in order to obey the RPC, and when the attorney is defending himself against a charge from the client. The duty of competence. A lawyer shall provide competent representation to the client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. A lawyer can become competent through study or via association with a learned mentor. Duty of candor. A lawyer may not knowingly make a false statement of material fact or law to a tribunal, fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client, or knowingly offer false evidence. Lawyers should refrain from filing frivolous lawsuits and should timely respond to all judicial requests. Duty of decorum. All Florida lawyers agree to uphold the standards of honor, integrity, and fair play in a cohesive commitment to equal justice under the law and to the public good. Lawyers should show respect toward others, including opposing counsel and members of the court. Conflict of interest. With respect to former clients, an attorney cannot represent a new client in a case in which an old client will be adversely affected without consent from the former client, and the attorney cannot disclose confidential material in order to disadvantage the former client. With respect to prospective clients, if the lawyer recognizes potential conflicts of interest with the prospective client, the lawyer cannot represent them without informed consent and reasonable belief that they can represent the client without compromising their professional judgment. A conflict of interest is imputed to the rest of the law firm unless there is formed consent in writing, the lawyer took steps to avoid disclosure, the lawyer is timely screened, and the prospective lawyer gets notice of the conflict. Conflicts are imputed unless they are personal to the lawyer or the conflict does not risk materially limiting representation by the rest of the firm. Attorney's fees. Attorney's fees are allowable in Florida as permitted by statute, rule, or sanction. Attorney's fees must be reasonable and are considered clearly excessive when they're overreaching or unconscionable. They are presumed reasonable if agreed in contract or writing. Duty not to commingle. If an attorney is advanced costs or fees, they must be kept in a separate account from the firm's operating expenses. Contingency fees. A contingency fee is a type of payment arrangement where the lawyer only gets paid if the client prevails in the litigation. Contingency fees are not allowable in domestic relations or criminal cases. Otherwise, they must be in writing and include a description of how the fee will be calculated, and before disbursement, a final calculation showing how the fees are being divided. Referral fees. Referral fees are not ethical unless the amount is divided proportionally to the work performed, and there must be a written agreement with the client advising of the joint representation, detailing how the joint representation will be conducted. Interest in client property. In order for an attorney to receive an interest in client property, the lawyer must get the client's informed consent, and the agreement must be fair and reasonable and disclosed in writing. The client must also be advised of the opportunity to seek outside counsel. Advertisements. All advertising materials must contain the attorney's name and field, and the advertising attorney must be registered with the Florida Bar. The advertising materials must not be misleading and thus cannot contain material statements that are false or misleading, such as claiming 100% success rate after winning one case, omits vital information, or implies the existence of a non-existing fact. Solicitation. Lawyers must not solicit anyone other than an existing client or someone with a close personal or family relationship, but they can send a letter to an accident victim if 30 days have passed. When a lawyer is speaking to represent people, he or she cannot talk about the matter for which they're being represented. When speaking to unrepresented people, an attorney cannot appear disinterested when not disinterested. Rules of private practice. A lawyer must be barred in Florida to practice in a state unless the lawyer is associated with an active lawyer, is granted pro hac visa admission, or the litigation arises out of their home state practice. Additionally, lawyers do not always need to be barred in Florida if they're employed by only one client, in-house counsel, or they practice in restricted branches of law, like federal agencies. Lawyers cannot assist people in the unlicensed practice of law. Supervisory attorneys must make reasonable efforts to ensure that actions by subordinates conform to the RPC. Supervisory attorneys are responsible for the subordinates' actions if they order or ratify the act and knowingly fail to take remedial action. Sale of a law practice. If an attorney decides to sell a practice, the entire practice area must be sold. Fees to clients must not increase as a result of the sale, and the attorney must be given notice to clients about the sale and provide them an opportunity to retain other counsel or to collect their file. Alternative dispute resolution. Mediation is a form of alternative dispute resolution and may be used in place of a court proceeding. Their attendees will be the parties and their lawyers and neutral mediator. Any offer or statements in mediation are confidential and can not be used in court unless discoverable some other way. Decisions in mediation are non-binding. Arbitration is similar to mediation, but uses an arbitrator rather than a mediator, and the decision is binding on both parties. And one more time for good measure. The ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the Ideals and Goals of Professionalism, the Oath of Admission to the Florida Bar, the Creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. The possible consequences for failure to comply with these ethical duties are suspension, expulsion, and admonishment. I'm confident you, Stick Boy, and excited to hear from you soon. Andrew. Conclusion. Be confident in yourself, and when in doubt, write it out. You do not get points for thoughts, only for what you've written. Utilize the IRAOC method and consider counter arguments to your conclusions. Be mindful of your time, as you do not want one essay to intrude upon another. Remember that this is just a test. As long as you are committed to working hard, everything will work out just fine. And as my grandma always said, be a good person. And here you can see the actual letters that my grandfather wrote to me back in 1997.